Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5243 et al. Giorgi Srinivasan, appellant, versus Robert S. Mueller III, special counsel for the investigation into Russian interference in the 2016 presidential election and United States Department of Justice. Mr. Madden for the appellant, Mr. Janda for the appellees.
Morning, counsel.
Morning, Your Honor.
Mr. Madden, please proceed when you're ready.
With respect to Article 3 standing, the court initially held that Mr. Rtskhiladze had plausibly pled that the implications of footnote 112 caused him business and reputational harm. But then it turned around and said the Senate report, which was issued 15 months later, constituted an independent injury, and therefore, for prospective relief, the harm from the footnote was no longer traceable. And for damages, he could recover damages after the release of the Senate report. The Senate report did not harm Mr. Rtskhiladze. There's no defamation in the Senate report. In fact, Mr. Rtskhiladze uses the Senate report to show how the implications of footnote 112 were so defamatory. Also, this was not an argument that DOJ made for the district court. This is something the court on its own came up with. There wasn't any briefing on the issue, so it was surprising. For the Senate report to constitute defamation by implication, it would have had to stated that he was a Russian businessman, which it did not, that he had personal knowledge, implied that he had personal knowledge about these tapes, which he did not, and that he took active steps to suppress those tapes in Russia before the election, which he did not. The Senate report does no such thing. It, first of all, includes the full text, which footnote 112 did not do. And when the context of the full text takes the implications of defamation away. For example, footnote leaves out Mr. Rtskhiladze saying, not sure of the content, a person in Moscow bragging about tapes. I'm sure it's no big deal. That's in the Senate report. That is not in footnote 112. The Senate report shows the context that all Mr. Rtskhiladze had was a phone call from a friend to him in Connecticut saying that his friend was at dinner and overheard somebody talking about tapes. That's the only knowledge he had, and then he took no action. He had no personal knowledge, the Senate report says, he took no action. And with respect to the Crocus group, which gets mentioned in the footnote, the Senate report shows that that was something that was made after the Steele dossier came out, which wasn't out at the time of the text or the election. And so he just said, well, I told him there was maybe something there. And that's all. It's in the Senate report. So it's not defamatory. The independent harm argument is illogical. It's like saying the New York Times defamed my client, but the Washington Post 15 months later defamed my client, and therefore you have to dismiss the case against the New York Times. That's just not plausible.
Can I ask you?
Yes, sir.
No, please go ahead.
No, go ahead.
Can I ask you about your desire for access to the transcript?
Yes, sir.
I think that Judge Cooper reviewed the transcript when he denied reconsideration. Is that correct?
Yes, sir.
So if that's the case, why is your desire for the transcript, why is that claim not moot?
Claim is moot because this case is like any other case the DC Circuit has addressed. This is a case where the Department of Justice itself put into the public forum in a highly media feeding frenzy part of the transcript. And when it did that, it misquoted the transcript and it left out material parts. And so DOJ's arguments about policy, they have been waived.
Why do you want the transcript?
Transcript, like the Senate report, gives the full context of what Mr. Rtskhiladze knew. If you can't get that from footnote 112, in fact, it defames on my implication, but the transcript as a whole does not. And that's why we think it's only fair to release the transcript to Mr. Rtskhiladze. The Mueller investigation is over. There's I mean, this footnote destroyed my client's livelihood. All he wants is to be able to go to the public forum and say, look, this is what I actually said. That's all. That issue.
The whole point of getting the transcript is to disclose it.
Yes, sir. The Senate report is also irrelevant to a statutory cause of action, which we have here under the Privacy Act. In Spokane, the court.
Okay, so say we agree with you that your client had standing on these equitable relief claims. Can you address whether you've even stated a claim for equitable relief under the APA or under the Privacy Act? There
Yes,
seem to be
yes.
some hurdles there in terms of whether there was a final action under the APA and whether this was, I guess, a group of records under the Privacy Act.
Under 552A G1A, if a person makes a request for amendment and is denied, the person is entitled to sue in court if it's in a system of records. And DOJ argues that it's not in a system of records, but that is system of records in the Privacy Act is not set. It's not meant to be set in stone. Okay, so all it has to be is something that the agency uses to acquire information about a person by some identifier. And this is not 1974 when the Privacy Act was enacted. And so it just stretches credulity for DOJ to argue that this is not in a system of records, because I'm sure.
If I may, isn't the definition, it's a group of any records under the control of any agency from which information is retrieved by the name of the individual or by some identifying number, symbol, or other identifying particular assigned to the individual.
Correct, Your Honor.
What's the Mueller report?
Example, if there were a FOIA request for this information, DOJ would not go through page by page. They have it. They would. I'm certain they have a model program that goes through, picks out the name, picks out any information you want on an individual. They don't go through this page by page. This is not 1974. Technology has come a long way, and particularly this court has said when it's a formal investigation, the interests of privacy are at their highest. In any case, if the court doesn't agree with us on that, he's entitled to relief under the APA. Now, violation of 552 G1C says the agency must keep records that are accurate and complete so that there's no adverse determination.
But there has to be a final agency action.
Yes, Your Honor. And DOJ argues that the final agency action is the Mueller report, but that's not what we're arguing. We're arguing that the decision by the Attorney General, who would announce that any information about a non-target that would be harmful would be redacted. It wasn't. And that's the final agency decision. He used his discretion under CFR 28-600 to do that. So now it's true that in an APA case under that section, there's no de novo review as there is for 552A failure to amend. It's abuse of discretion standard, but there's nothing in 552AG that says there's no equitable jurisdiction over a violation of C. It says if there's a violation of C, the district court shall have a jurisdiction.
Can I go back to the grand jury materials, the access to the transcript just for a second? So if I'm understanding your argument, you only want the transcript so that you can disclose it, so that your client can disclose it to correct the record in the eyes of the public.
Yes, sir.
So does that mean that there's no independent interest in actually having the transcript itself, as opposed to being able to go in and look at the transcript, unless you can I mean, in some other cases, for example, somebody may want the actual transcript so that they can refresh their memory, and they want to make sure that they have it right. And then the question comes up, well, you can go in and take notes. What's the difference between taking notes on it and actually getting the physical transcript itself? As I understand your argument, you don't care about actually having your hands on the transcript unless it can be disclosed.
That's right. You're right. We have looked at the transcript. We have taken notes. We filed a declaration on that.
Okay.
But our argument is when the government itself discloses part of the transcript and defames the non-target, the target is entitled to have the transcript to protect themselves. And
I mean, in other words, one way to think about this is we have our in re grand jury case in which we talked about access to the transcript so that the witness can go in and look at the transcript. And then we specifically carved out whether the opportunity to go in and look at the transcript also means that you actually get a physical copy of the transcript. We weren't even talking about disclosure of anything,
right,
the notes or the transcript itself. But here, you're not worried about that distinction because it doesn't do you any good to get the transcript itself unless you can actually disclose it.
That's right. Yes, sir. I may touch on the damages claim under the Privacy
Can
Act.
I ask though, is that preserved? Because it was not my understanding that you had asked the district court for access to the transcript so you could disclose it.
Yes, we did. Specifically asked for
Okay.
that the transcript be produced without restriction.
Can you point us to where you did that? And I know it might be hard to name it off the top of your head, but maybe in your rebuttal if
I can, if I try to find it, if I can't, I'll send it to H228J immediately. We did request the transcript itself and unrestricted. It was denied by the
I
judge.
think the question is, you requested the transcript so that you could disclose it.
Yes, we requested an unrestricted copy of the
That's what you
transcript.
said.
Yes.
You made that argument.
Yes, sir. We certainly did. If I may just touch on the damages claim, the court went on and said, either it's Article 3 jurisdiction for this damages claim under the Privacy Act, that my client hadn't plausibly pled that the defamation was willful or intentional. When it did that, it applied a different standard than it did for standing. For standing, it looked at the footnote as a whole, said, yes, I agree. The implications of this footnote are defamatory. On the damages issue, it said, no, look at the Senate reports, just sort of, just a little bit, almost the same. That's not what we're arguing. Once you show, and the court agreed, that there is defamation by implication, in that kind of a case, intent is presumed. So dismissing the case on the pleadings as a matter of law was improper. Even true statements can be defamatory by implication, and intent is irrelevant to those cases. And of course, you don't even need to prove actual intent in a Privacy Act case. It's just a little more than gross negligence or reckless disregard. So the court applied two standards for looking at the intentional willful part of the Privacy Act, which is clearly wrong based on our theory of the case. And of course, the record shows there is a clear conflict of interest with the chief prosecutor in this case. She did not tell Mr. Mueller about her connection to Hillary Clinton. And she certainly had control of the pen, and she had motive and opportunity to do what footnote 112 did for political reasons. And my client was caught in the crossfire.
Thank you, counsel. We'll hear from unless my colleagues have further questions, we'll hear from the government now. Mr. Janda.
Thank you, Your Honor, and may it please the court. Sean Janda for the federal government. I'm happy to address whatever questions the court might have, but in the absence of more specific direction, I think it might be most natural to start with standing. And to do that, I think it's helpful to sort of take a step back and really focus in on the statements that the plaintiff here claims are defamatory or inaccurate, and the ones that he isn't challenging, even in the Mueller report itself. And so, the plaintiff, I think, has not disputed that he was in communication with Michael Cohen in 2015 and 2016 before the election, that there was communication about building a potential Trump Tower project in Moscow, that Michael Cohen contacted plaintiff because plaintiff had experience with business ventures in Moscow, that he discussed with Michael Cohen the possibility of a meeting between Mr. Trump and the highest level of the Russian government, that he suggested to Michael Cohen that they send a letter to the mayor of Moscow and sort of intimated that the mayor of Moscow knew about the project and would support it. And he doesn't dispute that he, in fact, was texting with Michael Cohen in October 2016 about the rumors of these tapes. And so I think against that extremely large amount of conceitedly true and non-defamatory information in the Mueller report, it's just really hard to believe that these specific alleged inaccuracies or the asserted sort of defamatory implications of the footnote have caused the plaintiff any concrete reputational injury. And I don't think that there's anything in the complaint or in the declaration that was filed in district court that really does the work of homing in on the sort of specific distinction between the alleged defamatory statements and all of the other statements, and demonstrating which has caused any.
Are you focusing on the idea? It seems to me you could be making two arguments here. Maybe you're making both, but one of them is, look, don't worry about the stuff that the plaintiff is focused on, because there's other stuff that corrects any misimpression. So this is kind of trivial, because anybody who reads the entire Mueller report will see that on page 1 it says X, on page 994 it says Y, and if you put the two of them together, you'll see that the correct information is actually in there. That's one way to look at it. The other way to look at it is to say that the thing that you're focused on actually isn't all that big a deal, period, because it's, it's just little subtle distinctions, like the addition of the word some and having Russian or not Russian in there itself is not a big deal, regardless of corrective information that's elsewhere. Are you focusing on the fact that there's the correct information somewhere else? Or are you focusing on the fact that actually this isn't all that big of a deal?
So I think there's a little bit of the first one, particularly with the US-based executive of a Georgian company description versus the Russian businessman description. And I think that the first one is accurate and is in the Mueller report. But more fundamentally, it's the second. And I think there's just a lot of information in the report. And so, as I understand the plaintiff's sort of theory, it's kind of a time-based theory that after the report came out, he lost various business opportunities or other opportunities. And because there's so much true information in the report, I think that sort of time-based theory doesn't get him home. I think he has to sort of demonstrate that it's the stuff that he's actually challenging in the report.
Yeah, I mean, that seems like tailor-made stuff to win on causation on the merits. He's just not suffered any damages. And actually, if you look at it, it's really hard to believe that you can construct a theory by which that he can make out a claim for relief, because there's so many other intervening causes and there's so many other things that factor into it. At standing, it seems like asking a lot to say there's some stuff that the district court thought was actually problematic. In theory, at least at the motion to dismiss stage, because it's plausible. And then to say, yeah, but then there's other stuff, elsewhere in this report, and then other stuff elsewhere out in the world, that actually, if somebody was omniscient and read everything in the world, they would realize that this isn't that much of a big deal. It seems like asking a lot at the standing stage on a motion to dismiss.
I don't think so, Your Honor. I mean, I would point the court to Ezel Trucking, which is one of the court's cases that we cite in our briefs, which makes clear that to really make out a concrete injury at the standing stage, in this sort of reputational injury context, you do need to at least have kind of the plausible facts that would give rise to those allegations, or to the conclusion that you are harmed by the thing that you're challenging. And it might be that there are facts that the plaintiff could have alleged that he hasn't. But I think just like any other plaintiff, it is the plaintiff's burden to come in and allege the relevant facts to get home, even on the standing piece. I mean, they might also be very good causation arguments if you get past standing. But it's certainly, I don't think you can skip over the standing analysis on the basis that it's just sort of hard for the plaintiff to do the work that the plaintiff has to do to make out standing. And then, I think the other piece of it is that even if you assume that there was some injury, in fact, some number of years ago when the Mueller report was released, as the district court found, it's sort of hard to understand how that would be redressable by a judgment today, when you have the intervening Senate report, which contains a lot of discussion about the plaintiff. I think I searched the relevant volume and his name appears in it more than 100 times. There are sort of very extended discussions of contacts with Russia, of contacts with Michael Cohen, of the text message exchange that's referenced in footnote 112. And I'm not entirely sure what the plaintiff's sort of specific theory of addressability is, but it's hard to understand how a judgment, particularly when he could sort of distribute the Senate report to business contacts, if he thinks that they're refusing to do business with him because of misimpressions created by the Mueller report that would be corrected by the Senate report.
But might there be people who might be aware of the report and haven't read the Senate report?
That might be possible. I have no idea.
Yeah, I mean, boy,
So that's standing, isn't it?
Me. I don't think so. I mean, people who, the relevant class of people, I think, would be people who have read or are aware of the Mueller report, don't know anything about the Senate report.
It's highly speculative, I think. I think anybody who might have read the Mueller report and wasn't aware of the Senate report, if you concede that he had standing just based on the Mueller report before the Senate report came out, there'd still be standing. It's any injury.
So I don't think so, Your Honor. Well, there's two things. I mean, one is there's the injury piece, which we are contesting, but then the redressability piece is it's not just people who read the Mueller report but haven't read the Senate report. It's people in that category that would then be aware of the judgment and would sort of revise their impression or conduct in some way on the basis of this court's judgment. And I don't think the plaintiff has demonstrated that there is sort of some group of people out there that would be aware of the report and the judgment, but not the Senate report.
So that would be true. Let's just assume that there's just a blasphemously defamatory document out there. And everybody agrees that it's totally false and it's totally defamatory. And then a couple of years later, a second document comes along that has a different rendition that corrects the record. There's no action, as you only have standing to dispute the first one?
I mean, I think this doesn't come up that often, Your Honor. I mean, usually defamation is litigated in state court for damages where the redressability question just isn't really live. But I think we're not asking the court to adopt any sort of bright line rule or broad principle. I mean, I think the legal rule is given by, for example, this court's decision in Renal Physicians, which is that to show redressability, it's the plaintiff's burden to sort of plausibly allege the facts that could lead to the plausible conclusion that the third parties will sort of change the way that they are interacting with the plaintiff or will stop injuring the plaintiff on the basis of the judgment. And I think just in this very fact-specific context, the plaintiff hasn't done the work to make that demonstration.
Can I ask you about the second action before Chief Judge Howe, unless you had more, did you have more questions on the first?
Well, I just had one question. If we disagree with you on the standing issue, do we have to remand to the district court, or can we just hold that there's a failure to state a claim on those issues?
I mean, I think the court certainly can hold that there's a failure to state a claim. I mean, the district court actually dismissed the Privacy Act damages action on the merits, and this court certainly could affirm that. And then
equitable.
For the equitable stuff, I think we haven't asked the court to amend the judgment in any way. I think we're fine with the dismissal without prejudice, and it would be fine for this court to affirm the dismissal without prejudice on the alternative ground, the alternative merits grounds that we've presented, and that I think are fully briefed before this court.
I know we can, but I guess the question is, should we?
I mean, I don't think those are pure questions of law. The question about certainly the final agency action question and the question about the system of records. I don't know that sort of any further development in the district court would be helpful or useful in any way. And so certainly if this court thinks that we're right on those threshold issues, we presented them to the district court. The district court didn't feel the need to reach them because it agreed with us on standing. But I think they're sort of fully aired for this court's decision.
But I hadn't thought completely about the without prejudice with the prejudice, actually. So if the dismissal is without prejudice, if the merits are reached, is it not a dismissal with prejudice?
So if the district court had reached the merits, it would have dismissed with prejudice. But my understanding is that it is appropriate for the Court of Appeals to affirm the dismissal without prejudice, even on merits grounds. I mean, we're not asking to amend or correct the judgment in any way. And certainly sometimes you would have a dismissal without prejudice, even on a merits ground if you were giving leave to amend or something of that nature. So I don't think there's any sort of problematic thing about this court affirming on the grounds that we present. But turning to the...
So let's say we do exactly that. We affirm the district court, we affirm Judge Cooper's judgment. Does that make Chief Judge Howe's case moot?
So I'm not sure that it would make it moot, Your Honor. I think it would change the analysis. I mean, so to the extent that the plaintiff is getting in to Rule 6E under the exception for sort of disclosure in connection with another pending proceeding or another civil proceeding, it certainly would change the analysis. If there's no pending proceeding, I would think you would be able to get under that. But
Well, I can. Okay.
But why wouldn't it be moot then? I mean, I get one argument would be that if let's suppose that the transcript actually helps bolster some of the merits claims, including on the Privacy Act, because it can show the requisite degree of intentionality or something like that. Then in that situation, getting the transcript actually would make a difference.
So I think I understood Judge Walker's question to be if the dismissal of the civil action is affirmed, so there is no more civil action where the transcript could help on the merits at that point, then there's still the pending request. I mean, you can make an unmeritorious request or a request that doesn't comply with 6E, and so I'm not sure that would be moot. I think were that all to happen and were this court not to just affirm Chief Judge Howe's decision.
I don't understand why it's not moot actually either way, regardless of what we do in Action 1. I think his motion in Action 2 before Chief Judge Howe about accessing the grand jury transcript, His motion was titled, he wants an order denying unrestricted access to the grand jury transcript, or alternatively, an order for the Department of Justice be directed to file the transcript under seal in the related case. And he got the alternative relief. So what's left?
So I think we have understood the request to be, primarily a request for unrestricted access, so we can get a copy of the transcript, so we can disclose a copy of the transcript.
Sounds like he said, I'll take either.
Maybe, and I think, a lot of the arguments he's now making in this court, now the transcript has been filed about sort of correcting the public record and sort of correcting whatever misimpression he thinks was left by the report, weren't really aired in the district court. But we have understood Judge Howell's, Chief Judge Howell's opinion as at least denying in some part the relief that he was requesting. If this court thinks it's moot, I'm not going to fight you too hard on that, but
You sort of are.
it's certainly not how we have been thinking about the issue. And I think on the merits, again, it is quite easy for this court to affirm on the merits. There was really no articulated justification in front of Chief Judge Howell to support the need for unrestricted access, particularly in light of the sort of ability to have taken notes and to have disclosed the notes and the impressions of the transcript in connection with the civil action.
And can I ask, would it not be moot until the period for rehearing or for seeking cert expired?
Maybe certainly it will be challenging at that point or even at this point, right, to put additional information into the record if that's kind of the hook for the liveness of the claim. But I think to me, that's a merits issue. It's a sort of question about whether one of the Rule 6e prerequisites to disclosure is satisfied. It then sort of opens the door for the district court to permit disclosure. I don't think it's a jurisdictional issue. If someone came into court and said, I just really want a copy of my transcript, there's no pending civil proceeding, but I want a copy. I don't think we would say that's sort of a moot case. It was just going to fail on the merits because Rule 6e provides sort of the full set of circumstances in which the district court may authorize
What if the
disclosure.
plaintiff voluntarily dismisses the underlying action?
I think as long as the plaintiff sort of keeps the request in front of the district court, then I'm just not sure it's a mootness problem. If this court disagrees, we are perfectly happy, I think, for this court to say that it's moot at this point. But it's not how we've been thinking about it.
So even if they dismissed it, then you think they could still take an appeal of the request for access to the transcript that is to be used in the action that they dismissed?
I think they could take the appeal. If the court thought that the original denial was on its own terms an abuse of discretion, then maybe the court would send it back and the district court then, in reevaluating the request, would take account of the changed circumstances and say, well, now that there's no civil action pending, you have no need for the transcript or Rule 6e is not satisfied. But I don't necessarily think that would moot the appeal.
Can I ask one question about the merits of the Rule 6e question? So if we're in a situation in which there's an entitlement to look at the transcript and to take notes and to basically transcribe the transcript by taking notes, then can I just hear your articulation of what the additional interest is in not disclosing the transcript itself?
So I think there's a couple things there, Your Honor. And so I think sort of number one, and maybe the most important one, is the one that was sort of articulated by Justice Brennan in dissent in the John Doe case, and then was sort of picked up by this court in grand jury, which is that actually coming out with an official copy of the transcript and having the automatic right to that copy of the transcript does provide an opportunity for any individual that might have control over a witness to sort of force the witness to come out with a copy of the transcript, check the witness's testimony to see what the witness said in a way that might well chill sort of free and candid testimony on the front end.
So that person could still force the disclosure of the notes if they have access to the transcript, look at it, take the notes. And I take it in that situation, at least the person can protect themselves because they don't have to turn over the actual notes. They can make up some other notes. There's at least a delta.
At least, right, some delta there. And I'm not sure even that in grand jury stands for the proposition that you have to be able to disclose the notes. Here the district court imposed sort of restrictions on.
But if it's a pressure situation, then the whole thing is about disclosure, because if it's a third party who says, hey, go in and figure out what they're doing and let me know, then we're just assuming a circumstance in which that might come to pass.
Right, but I think the district court could well say, you have no automatic right of access to the transcript. You can take your notes, but I'm going to tell you, you can't disclose them to anyone. And then that would sort of cut off the, potential pressure, even setting aside the ability to, fudge things in the notes or whatever, that might exist there.
And does that argument, if we rely on Justice Brennan's notion, is that just something that's going to work in every case? So there's just a presumptive disentitlement to the transcript, and the government doesn't, even for a witness, doesn't have to come forward with a specific justification as to why there shouldn't be disclosure of the transcript itself to the witness?
I think probably, but that's just what Rule 6E is. I mean, there's a strong bias in favor of grand jury secrecy, and a grand jury sort of grand jury carves out that specific circumstance where the witness gets access. But I think as a general rule, any
because of the witness,
right?
So we're in a land in which it's flipped a little bit because the person's actually the witness, and they could go out on the courthouse steps and announce everything that just happened.
Right. So I think this court has carved out sort of an exception to the usual rules. But I'm not sure that means that sort of the exception should expand to swallow the usual rules. And the usual rules here are very strongly biased in favor of secrecy. And, I think as we explained in our briefs, there is a pretty significant delta between the witness being able to just sort of say, here are the kinds of things I talked about, and the witness being able to obtain a copy and to show sort of, here are the exact questions that were asked, here is exactly what I said. There may well be sort of other individuals who could understand from the transcript things that the witness themselves might not understand. There's always sort of the veneer of not being entirely sure how truthful or accurate the recollection of the witness is. And all of those just go away when you have a copy of the transcript to sort of wave around in public.
Okay. Make sure my colleagues don't have additional questions for you.
Great. Thank you.
Thank you, Mr. Janda. Mr. Madden, we'll give you 2 minutes for a rebuttal.
Thank you, Your Honor. With respect to the assertion, it's hard to believe there were damages. That's premature, first of all. And secondly, Mr. Rtskhiladze has filed a declaration showing how he was damaged in that case. With respect to this, I can't believe this really harmed him. All you have to do is look at Rachel Maddow's transcript from a couple days after the footnote was made public, and said, so that means Trump knew that somewhere in the former Soviet Union, a business buddy of his had taken action to make sure tapes, supposedly from Trump's trip to Russia, those tapes weren't getting out. Don't worry, all taken care of. I took care of that for you, right? There's the damage. That was a feeding frenzy worldwide on that issue. The failures to state a claim, just to reiterate, we believe they're standing under for equitable relief under the Privacy Act, damages under the Privacy Act, and under the APA. You're on the question of whether we asked directly for the transcript to be made public. I know we did. I cannot find it. I will submit it.
I just want to be clear about what my question for you is, though. I'll assume that you asked for the transcript with the authority to make it. I'll assume you asked for an unrestricted access to the transcript. But I'm wondering if you made the argument, we need unrestricted access to the transcript so that we can disclose it to the public.
Yes, Your Honor. I'm certain we did. I will find that for you. I will submit 20HA either this afternoon or tomorrow morning. On the policy issue of disclosure, as the court has said, the testimony belongs to the witness. That's the first rule. In this idea of policy, well, if you get the transcript out there, it's going to control the witness. That is not applicable in this case. Mueller investigation is long gone. So we ask that this case be reversed, remanded, and sent back to district court with instructions from this court. Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-1278 et al. Antero Resources Corporation and MU Marketing LLC petitioners versus Federal Energy Regulatory Commission. Ms. Taylor for the petitioners, Antero Resources Corporation and Equity Marketing LLC. Ms. O'Neill for the petitioner, EGT Energy LLC. Ms. Benta for the respondent, Mr. Foreman, the interveners.
Morning, council. Ms. Taylor, please proceed when you're ready.
Thank you. Ready. The entire premise for the new PCG paper pools was that they would provide increased liquidity in the market for responsibly sourced gas, and that gas aggregated at the pooling points would likely trade at a premium. Both Tennessee Gas Pipeline and FERC endorsed this rationale. The PCG criteria govern who can and who cannot access the pools and all of these benefits. It's hard to imagine a term that could more significantly affect this FERC jurisdictional service. And yet FERC has disclaimed oversight of the gateway criteria for the PCG pools altogether.
Council, can I give you a hypothetical which would help me understand your position on standing in this case? Let's say that I'm a railroad regulator and you are a railway operator. You're a company that runs trains. You have a train with 2 cars. These cars are identical. They run on the exact same timetable, at the same price, and to the same destination. But car 1 only carries organic food, and car 2 carries any kind of food, organic or otherwise. You, the train company, decide to post the criteria for defining organic on your website. Then a farmer who sells organic food sues me, the regulatory agency, and says that I should require you, the company, to put the definition of organic on a document that's submitted to me, the regulator. The farmer says the fact that the company is defining organic food could affect the price of organic food. Has the farmer shown that he has suffered a concrete injury inflicted by me, the regulator? Have I harmed him by letting the company put the criteria on the website instead of in a document submitted to me?
I think that if in your hypothetical, the regulator, the filing of the document with the regulator was the predicate for review for those criteria as just and reasonable, then there is a procedural injury in your hypothetical. The purpose of the public filing requirement, and it's a statutory requirement, it's something that's very well established in FERC's own regulations and in the precedents of this court, is because that then prompts the Section 4 proceeding in which the pipeline has to show that this is just and reasonable, and FERC then exercises its supervisory authority and determines whether it's just and reasonable.
But how are you harmed if you're the farmer by the fact that the criteria is put in a website versus?
Because
in the
once the
document?
criteria is on the website, and also in this hypothetical, the regulator has said, not only are we not going to put that in the tariff, but we don't have jurisdiction over it. We're never going to review.
Well, in my hypothetical, which I think is on point in some respect, I'm a regulator of transportation. I'm not a regulator of what is organic food. And FERC is a regulator of transportation of gas, not the qualities of the gas. So I think that that's apt. So how are you harmed by me, the regulator, just saying this criteria, which I'm not in charge of, it's on the website and not in the tariff or in the document that's submitted to me?
Right, because as a customer of the railroad or the pipeline, that Antero has a procedural interest in, FERC's statutory duty is to protect customers of pipelines against the potential monopoly power of the pipelines. And so the fact that, so by agreeing that the service can be offered as part of the tariff, and then allowing the gateway criteria for the service to be sort of not just deferred, but completely excluded from jurisdiction. In that hypothetical, the regulator has allowed the railroad to create a market for something that everybody agrees is going to be valuable, and then has stepped back and said, despite the fact that we're the economic regulator of this entity, we're actually not going to take any responsibility for the gatekeeping criteria for who gets to access or not access the posited premium that everyone agrees is going to exist in this market. And I think just to also take a step back from, I don't want to bite the hypothetical. I'm happy to continue to discuss it,
I'm
but
trying to understand the procedural harm, though. Like, what is the
Right.
procedural harm?
the procedural harm is that as a producer of gas who ships gas every day on the pipeline and also produces responsibly sourced gas, FERC has said to Antero and other similarly situated producers, we're going to allow this pipeline to create a market that affects, that's a concrete interest, right? We're in the Lujan hypothetical. We live next to the dam, right? We have a concrete economic interest that's
But
going
it
to be
affects your interest in what respect? Because you can still transport your gas the way you always have. It's the same, I guess, all the same terms. And it seems to me that given that you can do that, this is just an informational thing. So how are you harmed by where that information is placed?
So I think this is a distinction that FERC attempts to draw in its brief between what it calls actual transportation, which is like, I understand that to mean physically getting gas molecules from point A to point B and scheduling.
I'm sorry, but even under the pooling program, the pooling arrangement is exactly the same.
But as a scheduling service, it's the same, but there's this, what they call an informational feature. There's two separate pools. First, there's paper pooling for ordinary gas and paper pooling for responsibly sourced gas. Everybody assumes, and FERC and Tennessee Gas Pipeline, that the responsibly sourced gas is going to trade at a premium. FERC is the economic regulator, right? It's not just, FERC's job is not just-
But the trading at a premium is not about the terms and services of transporting the gas.
I would submit that trading at a premium is the type of, FERC is
FERC doesn't regulate gas prices, correct?
It does regulate the prices that
Of transportation,
of transportation.
but not gas prices. And you're saying that the gas prices are going to change.
We're saying that FERC is looking at
The prices of transportation would be the same. It's free.
the scheduling service will be free. The actual transportation, I don't want to get hung up on those distinctions. But what FERC is saying is, I take FERC to essentially be saying, well, look, it's okay as long as you can, schedule your deliveries, get your gas molecules from point A to point B. That's actual transportation, and that's all that we have responsibility for. But respectfully, that is not their statutory mandate. They're the economic regulator of pipelines. Their job is to ensure that when pipelines offer jurisdictional services, and there is no dispute that paper pooling is a jurisdictional service, that's offered on a non-discriminatory basis to all of their customers. And that's the purpose of having these provisions.
But this is a non-discriminatory basis. You can use it or not.
Well, it is discriminatory in the sense that they're saying there's two different pools in which you can trade, and you can only gain access to the one where the premium will be charged if you meet these criteria. And yet we're not taking any position on what those criteria are, not only now, but indefinitely into the future. They're saying we have no jurisdiction. So again, they allow the service to be offered as a second scheduling service, the paper pooling service in the tariff. And yet, so that, they recognize that it's a jurisdictional service. And yet they're saying, well, we aren't comfortable, saying what organic food is or saying what RSG is. And so we're going to let the pipeline change those criteria at its discretion. To put the point a little bit differently, if you're the farmer and you're deciding, do I grow organic food this year or do I not grow organic food? And actually, you have to plan several years out. You're not able to rely on the stability of the definition of what constitutes organic food because it can change at any moment subject to the.
But FERC is not defining this criteria for the entire market. They're just saying for purposes of its pipeline.
They're allowing the pipeline to change the criterion at its sole discretion.
But even if that were in the tariff, couldn't they change it?
If it were in the tariff, they would have to change it by filing a change, and then FERC would review it.
But it's not immutable just because it's in the tariff.
But FERC is saying that it doesn't have any jurisdiction over this. So in other words,
I'm trying to understand why this is important to you, because if your issue is that this creates uncertainty, it doesn't make it certain if it's in the tariff versus on the website.
What is certain? So as a customer of the pipeline, right, the customers are making business decisions with the understanding that FERC is going to do its job as an economic regulator. And customers rely on the stability that that affords, that there's not going to be discriminatory terms and provisions in tariffs, that they're not going to be changed at will.
Let me ask you then, isn't your theory of standing then relying on the speculation that Tennessee is going to change things willy-nilly whenever they want with little notice, even though they have to give you 30 days notice? And isn't that speculative?
I don't think our standing is relying on that speculation. Our standing is relying on the fact that any business that's rational is going to take into account the stability of the market conditions and the regulatory picture when it makes decisions. And if you have a guarantee that the economic regulator for the pipelines is going to supervise, review any changes in criteria and make sure that they're just and reasonable, and that you will have an opportunity in that review process to have your say about the changes to the criteria, then you can make your decisions under, those conditions. If in contrast, the pipeline is able to change the criteria with 30 days notice at its will without that review for justness and reasonableness, then that entirely changes your expectations as a market participant.
I have just one last question on this. And where can I find this in your opening brief?
Pardon?
Where can I find this theory in your opening brief?
Well, in our opening brief,
Yes, because that's when you're supposed to establish standing.
We established in the opening brief that we ship gas on the pipeline, that we are a producer of responsibly sourced gas. We also cited in the section on standing the ANR pipeline case, which I think is a very good analogy, because in that case, one of the relevant factors was the pipeline, the pricing had effectively been, the pipeline had been ordered to raise its rates. And the customer was aggrieved by that order. And the court said, you don't have to wait until the, actual filing happens, because at that point it's going to be a fait accompli, right? This is your
view,
opportunity.
does every producer of responsibly sourced gas who uses the pipeline have standing? Even if they don't even need to say, I'm going to use the PCG pooling pool. They just have to be a customer that produces responsibly sourced gas.
Yeah, I believe that being a customer who produces responsibly sourced gas, who is a sufficiently concrete economic interest under this court's procedural injury cases to give it standing.
And you don't even have to say, I'm planning to use the paper pooling service.
Respectfully, no, because the point is that we're not able to even, make those planning decisions against the backdrop of FERC's economic regulation, it doing its job. If there's a sort of a chicken and egg problem here, right? Because unless and until those criteria are overseen by FERC, then
they've been in effect for a year. Is that correct?
They have been, but again, without this backstop of FERC oversight, right? So the point is that now producers are in the position. I mean, the fact that they've been in effect for a year, and
so you don't even have to state to establish standing that you want to use the paper pooling services, but only if FERC oversees them. You don't even have to say that. It's assumed.
We have a concrete economic interest in shipping gas, and we're a producer of responsibly sourced gas. So our procedural injury is that, when the criteria are, if the criteria are altered, that we wouldn't even have recourse to go to our regulator. So in that case, in that situation, the EPSA case is an analogy, right? EPSA had standing. It didn't have to assert or, predict that there was going to be an ex parte communication someday. They had an interest in the proceedings having, regularity and integrity that they knew that they were going to be and their members were going to be participating in. We're a customer of Tennessee, that's undisputed, and we have an interest in those procedures having their integrity and being overseen by FERC, and in fact, indeed even taking place, right? Because now FERC has said these criteria, we don't have jurisdiction over them. So it's not a situation where, we know that there's going to be a future rate filing, and at that point, there would be an opportunity to challenge the criteria if we have a substantive disagreement with the way that they're framed, or if they're changed in a way that we think is arbitrary. Because FERC is saying we don't have jurisdiction over those. They're not in the tariff. We are never going to review that kind of challenge.
So under your view, anytime a regulatory agency decides that it's not going to regulate it in an area, then an entity that wants there to be regulation so that it can talk to the agency about what the regulation would be, would have a procedural injury.
I wouldn't put it that broadly, Your Honor. What I would say is that when an agency, as here, has a statutory duty to ensure that any terms that significantly affect jurisdictional services are included in the tariff so that it can exercise that statutory duty to ensure justness and reasonableness, and it shirks that duty by saying, even though this is a gateway criteria, it obviously is going to affect access to this valuable market that we're allowing this pipeline to create. And therefore, you're not going to have that future opportunity, then there's a procedural injury.
But I guess that goes to whether you have a strong claim on the merits that they have a duty to regulate. But in terms of just the injury for standing purposes and redressability and traceability and redressability for standing purposes, it seems like what you're saying is if we would be able to talk to a regulator about the degree of a regulation that we wish that they would exercise so that we would have some back and forth with them about that subject matter, that's the kind of procedural injury that gives us standing to seek a suit, to bring seek relief that requires them to regulate in that area.
I think again, I wouldn't put it that broadly because the tariff is itself the sort of, it's the linchpin of this entire supervisory system. So the reason why the statute says you have to, terms that significantly affect jurisdictional services have to go in the tariff is because then they're filed under Section 4. That's where the proceedings happen, where affected parties get input into, whether they're just and reasonable. Then if they're going to be changed, there has to be another filing and a further proceeding. So we're not just sort of saying, hey, we want you to reach out and regulate this thing that may or may not be within your jurisdiction, and we feel a little bit aggrieved that you haven't done it. It's almost as if this is the predicate for the process that we get. And the reason why the statute is structured that way is to ensure that FERC can exercise its economic oversight authority, and therefore that participants in the market can rely on that backstop and understand that there's not going to be discrimination. It's not going to be regulated in an arbitrary manner.
That seems to back into the merits argument, though, because FERC gets to decide what substantially affects the rates, terms, and services.
One thing is that for standing purposes, I think this court generally assumes that we are correct on the merits. But also I would, but I don't think that, the procedural injury we can posit, and this is clear in Lujan, right? That the person who lives near the dam doesn't have to show that the environmental impact statement is going to come out the way that they want. They have an interest in the procedural regularity of the environmental impact, because if it goes, sideways, then their property is going to be affected. And again, we have a concrete economic interest here because we produce responsibly sourced gas and we do ship gas on the Tennessee pipeline. And so in that sense, we have an interest in the procedural regularity. In this case, is like the resident near the dam in Lujan or the association in EPSA that knows that it's going to be participating in these proceedings and knows it's going to have concrete interests that are affected and needs to have those proceedings actually take place in the way that the statute is designed for them to do.
Can I ask more standing questions?
Sure.
I do think that they overlap a lot with the merits arguments. Your standing arguments overlap a lot with the merits arguments. And I think you have some awfully strong merits arguments, frankly. If the new pooling service is a quote unquote service that Tennessee Gas couldn't have created without FERC's approval, first of all, do you think that's right?
Yes.
Okay. It's a service that Tennessee Gas could not have created without FERC's approval.
Correct.
And then you're a gas shipper that wants to access that service, right? And FERC has said to Tennessee Gas, you can decide who can and cannot access the service, right? Then it seems like you're injured because you are in a position where Tennessee Gas can deny you access to the service, and Tennessee Gas can only do that unless FERC has blessed the creation of the service that makes that possible.
Yes, I agree with that.
And that's probably all wrong if you're wrong about the merits, if it's not actually a service.
Well, again, this court does presume that we're correct on the merits for purposes of the standing inquiry. Pardon?
It was a friendly question.
Yes, right. And so, and again, that's almost precisely there's a Columbia gas transportation case where there was a pipeline that had, was offering paper pooling, but it wasn't in the tariff. And FERC, this is a FERC case. Pardon?
What's the name of that case? I can.
It's Columbia, I can give you the citation. Columbia Gas Transmission Corporation, FERC 63012, 1992. So in that case, the pipeline was apparently offering paper pooling, but it wasn't in the tariff. And so there was no way to know who was getting access and who wasn't getting access. And so the commission said, no, you have to put this paper pooling into your tariff so that it can be, that we can be sure that it's being offered in a non-discriminatory manner.
So I will check out.
I'm sorry, I just want to follow up on your hypothetical.
Okay, sure.
So under Judge Walker's hypothetical, the claim is that by allowing Tennessee to set the criteria, it's a way of barring some people from accessing that pool. In order to have a concrete injury to your client, wouldn't you have to give evidence, because we're here on an agency review, that you wanted to enter the pool but were denied based on the criteria they set? It can't just be a hypothetical. Some people will be denied access.
Well, I think in the EPSA case, for example, there was no requirement that the producers show that there was going to be an ex parte communication, and that it was enough that that FERC had passed a regulation that was going to allow those ex parte communications, and the association and its members had an interest because they were going to be participating in proceedings where that rule would be applicable. Again, this is, and Lujan is clear about this, when it's a procedural injury, you have to still have a concrete interest, which we do because we ship gas on the pipeline and we produce.
Can I ask you about a FERC standing case called Great Lakes Gas Transmission? It's from 1993. There, the court found standing, and it talked about present injurious effect on the company's business decisions and competitive posture within the industry. Can you make an argument that what's going on here has had a present injurious effect on your business decisions and competitive posture within the industry?
I mean, our argument is that at the moment.
I think you have made that argument. Can you
yes,
make it again?
That is precisely our argument.
Can you spell it out?
Right, because we produce responsibly sourced gas, we ship gas on this pipeline, and we are looking at a market that everybody understands is going to create it's going to have benefits. They're creating a new way to trade RSG with enhanced liquidity. Everybody expects it to trade at a premium. And we are, as competitors in this market, looking at that, and we are unable to evaluate whether the criteria for access to it are going to be stable, whether they're going to be just and reasonable, whether they're going to be supervised by this regulator at all.
But was that a procedural injury?
I'm not sure I'm hung up on whether it's a procedural injury.
Well, I think
that's not a procedural injury theory, right? The one that was in Great Lakes was not a procedural injury theory.
I don't recall the specifics of whether that was categorized as,
okay.
But I mean, to the extent that we need to, I mean, I think that the procedural injury cases are helpful because they emphasize that, you don't have to show that the decision is going to come out one way or another. We don't have to prove that Tennessee is going to arbitrarily or discriminatorily change the criteria, right?
Great Lakes involved a regulated party. The petitioner in Great Lakes was the party being regulated, not a customer of that party or some third party that's affected.
Yes, but the whole purpose of the regulatory scheme is to regulate the pipelines who have potential monopoly power in order to protect customers like Antero. So if anything, I
understand. I just think Great Lakes doesn't help somebody who's not a regulated party.
To the extent that it is.
Which you're not.
Well, we're certainly actively engaged with FERC on, in this area, but also if anything, we, as the customer who the scheme is designed to protect, have an even greater claim to the, recognizing the injury that we would suffer if our business decisions in this market are not framed with the backstop of FERC supervision that would protect our reliance interest.
Clarifying question, which is, and there may be a difference among the two petitioners. I'm just trying to get this straight in my mind. For your purposes, is is your position predicated on the idea that FERC has to wrap in the criteria into the tariff? Or would you be okay if they didn't wrap that into the tariff, but then they also didn't wrap in the pooling option to begin with?
We would be okay with both. Our primary, the primary relief that we requested was that they be directed to incorporate the criteria into the tariff so that they can be supervised. But if in the alternative, on the basis of the jurisdictional concerns that FERC has articulated, or for some other reason, the court decided that everything would be out, that would also give us relief. And that highlights the fact that, this paper pooling service is in fact creating value because it is offered by the pipeline under its tariff, right? There's an ability to create an enhanced liquidity in that market. And so as long as that's the case, the criteria need to be in the tariff. Otherwise, if the whole thing is excluded from the tariff, we can go back to the bilateral trade system that currently has been the way
Which
that
you're fine
RSG
with.
is
So it's an
treated.
all or nothing proposition for you that
Yes,
as long as the orders get vacated, you don't
Correct.
care which way FERC goes. They just can't draw a distinction.
they can't do this half measure. Our first ask was that they include the criteria. If everything goes out, we would also be satisfied with that.
Your brief, you say you're an object of regulation, and then a minute ago you said you're not a regulated party. What's the distinction? What line are you drawing?
I think that the language object of regulation in Lujan is not really expounded upon in that opinion. But the point, I think the distinction that would be drawn is that sometimes you see cases where there's a attenuated theory of standing based on a procedural injury. If you go back to, there's a group that's saying, well, if this tax cut is enacted, that's going to de-incentivize the, production of a certain kind of product. And we have members who like to visit the lands that are near this, like that kind of, those parties are not the objects of the regulation who had the tax cut. Here, you have oversight of a market. Pipelines are the directly regulated entity, but they're regulated for the benefit of the customers who participate in these proceedings on a day-to-day basis. And so that's why, we believe we fall within the object of regulation line.
Thank you, counsel.
Thank you.
Ms. O'Neill.
Good morning, Your Honors, and may it please the court. Shannon O'Neill for petitioner EQT Energy, LLC. FERC's lack of jurisdiction and inability to ascertain the justness and reasonableness of the producer certified gas criteria left it with only one acceptable course of action below, and that would have been to reject Tennessee Gas's proposal in its entirety. Instead, FERC took the unreasoned half measure of allowing Tennessee Gas to bifurcate the fundamental criteria from the FERC jurisdictional service they govern. This harms EQT Energy because we're not only a shipper on Tennessee Gas, we are the market leader in production of producer certified gas. And what the proposal that Tennessee Gas puts in place does is essentially dilute the value of our market leading gas because it allows gas with potentially 4 times as much the methane intensity to be included in this same class of producer certified gas and potentially trade at the same premium.
Is based on your position that you're the market leader and so you're particularly disadvantaged by this, is your theory of standing the same as the theory you heard articulated earlier?
We have a separate theory of standing, Your Honor. Ours is specific to the harm to EQT. As the market leader, we are focused less on uncertainty in the market that might be interjected given lack of confidence in the criteria that Tennessee might set, especially given, again, that those have been removed from FERC's jurisdictional purview. Our concern and the harm to us, which commenced as soon as the service went into place, is that we have the lowest methane intensity gas on the market. Ideally, the relationship between methane intensity and the premium that gas demands should be inverse. We have the lowest methane intensity. We should be able to command the highest premium. We are harmed when Tennessee, as it's done here, for example, it's as if we're the A+ student and they switched mid-semester to pass-fail. We went from being best in class, having worked very hard, put in the time and effort to get there, to all of a sudden being considered on equal footing with a B- student. that is the harm to the value to us and the value of our
Right,
gas.
but the harm has to be related to the agency's action or inaction.
Correct. And what FERC has done is allowed Tennessee to put in place the service that perpetuates that harm. Despite FERC's acknowledged inability to ascertain whether the criteria that govern access to that service are just and reasonable. But again, regardless, and
So what
this,
would you have for, in other words, what would FERC do that
Give-
would remedy the harm you see from having a pass-fail system instead of the A+ system?
and this is what differentiates us from counsel down the table, Your Honor. The only appropriate course of action for FERC would be to throw out the proposal in its entirety. We are harmed regardless of whether the criteria are incorporated in the FERC jurisdictional tariff or not, because it's the existence of the service that dilutes the value of our gas that harms us. It is not directly whether or not FERC is able to control the criteria that gatekeep access to that service. And so because FERC, as it acknowledges, is unable to evaluate those criteria, the only appropriate course of action is for them to have rejected the proposal in its entirety. So we would be asking here that their orders below be vacated and remanded.
And they can't go in either direction for your purposes then. FERC just can't enter into this field at all.
That's
In
correct.
other words, they're worried that the other petitioner's worried that it's a half measure and you could either level up or level down. They wouldn't care. For you, that's not the case.
That's correct, Your Honor. FERC does not have the jurisdiction to evaluate the criteria. They've also acknowledged they lack the expertise. It's beyond their authority. So there is no universe where this is appropriately included in the FERC jurisdictional tariff.
What if there were no criteria? What if they just said you can have a paper pooling thing for RSG? We'll just let the market decide what that means.
I think that would be a different circumstance, Your Honor. I don't know under those circumstances, though, what would differentiate that from Tennessee Gas's existing pooling service?
It would be bilateral, that's what you're saying. Those are bilateral transactions. I guess maybe I don't understand the paper pooling PCG service. Is it that there's a pooling point, so all the buyers and sellers who want RSG go to that point, and within that point, you can't differentiate the A+ from the B- within the pooling point?
So if I can speak to, I think, what was your first question, what's going on with the pooling service generally? So this is paper pooling. So it's in essence an administrative construct that exists solely to increase liquidity on the system. It's kind of like if you put $50 into the ATM, you can get it out somewhere else across town. It's not exactly the same $50 bill you put in, but you're still getting that same quantity out. So it's an administrative system that's in place. And what Tennessee has set up under this proposal is a separate service that provides for that administrative pooling solely for gas that's able to satisfy the PCG, the producer certified gas criteria that they've established and that are separately now hosted on their website to change at will.
Right. So I think of it like as a meeting point for the buyers and sellers who want this particular kind of gas.
Sure. Yeah. That although again, there is physical pooling. So just to differentiate
Right.
this, it's a virtual meeting point of sorts.
But you're saying that in the bilateral market you're currently in, people can differentiate between the A+ and the B-, but at the paper pooling point, they don't have to because they're there. They have to meet some minimum criteria to be there. But within that pool, there's no way to differentiate between the A+ and the B-.
Within the pooling service, that's correct, Your Honor. All gas that meets the criteria that Tennessee establishes is producer certified gas. It doesn't matter if it's 0.5% methane intensity or 0.05% methane intensity or 0.2% methane intensity. It is producer certified gas as compared to in a bilateral transaction where we would be able to market the lowest intensity gas that we have available. And for certain consumers who are, perhaps under independent state or local regulatory.
But aren't you saying that you're harmed by any standard? Because you guys are the best. So any standard that lets in the B's and the C's and the D's would harm you. So any kind of standard harms you, whether it's by FERC, by Tennessee, or by anybody.
Within our universe of FERC regulatory scheme, yes, Your Honor. There are no broader governmental standards as to what constitutes responsibly sourced gas at present. It's possible that might change in the future, but that is wholly outside FERC's jurisdiction to wade into, which is precisely what they've done here, despite claiming that that's not their intent. Did that address your question?
Yes, thank you. I was just can you just walk me through the chain of, I guess, causation and redressability, et cetera, for your standing argument?
Sure, Your Honor. So Tennessee Gas comes to FERC. They put forth this proposal. Initially, notably also in their first go around, FERC threw this out entirely. That was docket RP 22-417. Tennessee Gas came in with the criteria incorporated in the tariff itself. FERC said, we don't have the expertise, we don't have the authority, we can't evaluate whether this is just or reasonable, rejected on those grounds. Tennessee Gas, seeing value in this proposition, comes back. They put forth a proposal that they think will comply with what FERC is looking for, and that is with the service itself in the FERC jurisdictional tariff and the criteria that gatekeep access to the service separately hosted on Tennessee's website. Throughout, EQT, in the initial docket, and again here, has commented and then protested and requested rehearing on the grounds that regardless of how that service is set up, we are again harmed because we, as the market leader, are deleteriously affected whenever there is a service put in place that dilutes the value of the highest quality top of class gas. And that is what the service does, because it essentially broadens the field. Tennessee has taken responsibly sourced gas, put their own sort of title on it, producer certified gas, and allowed that field to encompass not only the top of class gas, but also gas with 4 times the methane intensity. And that is a harm to producers such as EQT, who have put in the time, the resources necessary to continue to drive down the relative methane intensity of their gas.
So you're saying FERC allowed Tennessee Gas to post this criteria on its website. And because that criteria is on the website, some people will buy, I guess, grade B- or C gas instead of A+ gas.
Yes, Your Honor.
Isn't that speculative?
Your Honor, I know that FERC filed the 28J that shows the report from the past year that no one's entered into this, but it's not speculative because the fact that that exists, there is still that imminent harm that as time goes by, that service will become.
As soon as you get to as time goes by, we need an imminent harm.
The imminent harm, again, the harm commenced as soon as the service went into place. The fact that no one has utilized the service thus far is not determinative on a lack of harm.
But are you saying anybody who buys B+ gas subject to this paper pooling service with the criteria has harmed you?
It's not the customers who buy the gas that would have harmed us, Your Honor. It's FERC who allowed that service to go into place.
But the service has to harm you in order for FERC to have harmed you by letting it go into place. So I'm trying to figure out how the service harms you.
So an example, as a customer, I perhaps am under an independent regulatory mandate to go out and procure responsibly sourced gas. I could do that through a bilateral agreement with EQT. That's the system that was in place, is in place. But alternatively, there's this convenient, administratively efficient pooling service offered to me via Tennessee. And again, pipeline infrastructure is not fungible. It might be the case that Tennessee Gas's system is one of the only ways for me to procure gas. So rather than go to the trouble of entering into a bilateral agreement with EQT, instead, I think to myself, I'll use this administratively efficient pooling service. I get to satisfy my regulatory mandate. And on top of that, the service has the imprimatur of a federal government agency's approval.
But why isn't that speculative? You're speculating what a customer will do in response to this being there. And they could go to the paper pooling service and buy from you because you could be in the paper paper pooling service.
They could, Your Honor, but as a
So where's the standing?
well, as a participant in the paper pooling service, I'm again not able to get the full premium that I would through a bilateral.
You'd be
contract.
better off if you're in the bilateral rule.
Precisely, Your Honor.
From your perspective, just commercially, that seems like an identity. You'd be better off if you didn't have to share with everybody else. Because you can advertise yourself as the very best in the field. You should only do business with us because we have the very, very best. If you truly have the courage of your convictions and you really care about being as environmentally conscious as possible, you should come to us. Your theory doesn't have anything to do with the criteria actually being on the website. It has to do with the existence of the pooling option, period.
That's correct, Your Honor. FERC is under a Natural Gas Act mandate to ensure that the regulations, the qualifications, the standards that pertain to jurisdictional service are things it can review. And so it was it abdicated that mandate when it allowed Tennessee to remove those criteria and put them on a website. But we're again agnostic as to what the criteria are. FERC has no jurisdiction over this area at all. And the only way we are alleviated from harm is if the service itself in its entirety, soup to nuts, is thrown out.
The service being pooling service.
The producer certified gas pooling service, Your Honor.
Yeah, right. Pooling service for the, you said producer certified gas?
Yes, Your Honor.
Or RS, whatever the acronym is that's being used. Yeah, RSG, okay.
Yeah, there's a lot of acronyms.
So you just conceded, though, that it's efficient and easy and good for the market. It's just bad for your clients, and therefore it should be thrown out.
It's efficient and easy, Your Honor. It's not good for the market because it removes the incentive to continuously drive towards the lowest methane intensity gas with the promise of the reward of the highest premium. So those things are not the same. It could be the case again that it's preferable on the customer side, just for reasons of ease, but it still doesn't, it still depresses the ideal price in the market for the best possible gas.
Right. I mean, your whole business model presupposes that people are going to act in a disadvantageous way if it's just based on cost. You presume that people will be willing to pay more in order to get the most environmentally conscious production of gas.
It's beyond a presumption, Your Honor, because again, many customers are already under increasing regulatory
You're just
pressure.
operating on that assumption. And so your idea is, so because we're the best at it, we want to be able to make sure that people can act on the fact that we're the very, very best.
That's correct, Your Honor.
Can I ask a question about how the pool works? In my head, I'm imagining something like a wholesaler. So maybe actually before I start the question, I know how a bilateral trade works, right? And let's just imagine that it's let's borrow the Supreme Court's pork case from last year. So I know how a bilateral pork trade would work. There's a pork farmer and he sells to pork, people who kill the people who eat whatever, you know what I'm talking about?
Yes, Your Honor. I'm following.
Okay, now imagine that so it's a bilateral trade. A wholesaler would take a bunch of different pork producers, combine it into some giant warehouse, and then just sell to retailers from there. Okay, is that how the pooling service works? That there's people who produce the gas in a very clean way, in other words, the people who do like the free range pork. And there are the people who produce it in a dirtier way. Compare that to the not free range pork. They all sell to this wholesaler where all the pork kind of at that point is the same. And here in the pool, all the gas at that point is the same. And then purchasers buy from the pool. Is that how the pooling service works? Or is it more like a bilateral trade that just made a little bit more efficient?
I think if I can expand your hypothetical, Your Honor, I think it's close, but a couple key differentiations. So the whole idea of pooling on a natural gas system,
You speak up for me.
the whole idea of pooling on the natural gas system is to increase liquidity. So it's hard to draw a parallel to this in the pork markets, but it's as if I produced a pig in Texas, I sold you the pig, but due to the pooling, you're able to procure a pig in Virginia, but basically as quickly as possible. It's not the same pig. I sold you a unit of pig, but we've made it more efficient so that you can get it as quickly as possible, even if it's not literally the same pig I sold you.
So that actually does sound more like a bilateral trade that's made more efficient, as opposed to kind of buying from a middleman who has pooled all of the manufacturer's products.
Well, I think the differentiation, again, Your Honor, is that, again, it's tough with pigs, but it's almost as if there was, in between buyer and seller, there was a amorphous pool of, a virtual pool of pigs. And what Tennessee Gas has done is it's not just one pool of pigs. It's not your organic free-range pigs and your confined animal feedlot operation pigs all squished into one pool. It's two separate pooling points. We have one pool over here where we have our A+ pigs, one pool over here where just any pig can go in this pool.
But I thought with the two pools, in other words, are the RSGs and then the non-RSGs.
Correct, Your Honor, or the producer certified gas, the non-producer certified gas.
Producer certified gas. Okay. So for the producer certified gas, your problem is that where there's a pool, and yeah, it's a pool of only producer certified gas. Your problem is that it's a pool of producer certified gas, but you can't tell how great that producer certified gas is. Whereas in a bilateral arrangement, you could, because I would be telling you directly in a one-on-one communication, I'm the best. But in the pool, for some, is it just impossible to have the pool so that you could tell what the constituent components are of the pool, so that you could say, well, in some transactions, you're going to get mine, which is the very best. But in other transactions in the pool, you're going to get some other mix, which doesn't include mine. So you're not going to get my dose of the very best. Does it not work that way?
Generally, no, Your Honor. I don't think we could rule out some universe in which you could set up a extremely sophisticated pool, but that's not how this system is set up. And we would again run into the issue where FERC would be without jurisdiction or authority to evaluate whether that was just and reasonable.
I'm just trying to understand practically how the pool works. So practically how the producer certified gas pool, then somebody just says, the buyer, we want to get the benefit of pooling, but we also want it to be producer certified. So we go to the producer certified gas pool. And then at that point, the mechanism kicks in and you just get the gas, but you don't know exactly the ultimate source of the pooled gas.
That's correct, Your Honor, because the participation in the producer certified gas pool, all you have to do is, again, satisfy these criteria. And so any gas that's in that pool, as long as it's below the threshold that Tennessee Gas has established, it's good to go. But there's no specification as to whether it's your A+ again or your B-. It's just
that
anything.
information just isn't available in the pool.
Not the way the pool's set up, Your Honor.
That was my question, but he asked it so much better.
I enjoyed our conversation about pigs.
I have a question. So I'm guessing that your client does not participate in pools.
We do, Your Honor, because
Oh.
general pooling service has been around for a long time. And again, it's
So you find your bilateral buyers through a general pool.
separate transactions, Your Honor. There's gas that we have that participates in pools because, again, most pools exist strictly for administrative efficiency. There's no additional criteria that gatekeeps your participation in them. So it makes sense that you would participate in them just for general sales of gas. Separately, for customers for whom gas with certain environmental attributes, responsibly sourced gas, is highly desirable, we enter into bilateral agreements to provide that.
Right, because there has to be those customers who are so conscious and they want it to be so self-evident that they're conscious that they're going to just ignore the pool altogether, because they would have the same view you do, which is, I want to be able to show that I'm buying only A+ gas, and so I'm going to enter into a bilateral arrangement. If I did it through the pool, even though it's producer certified, it could be B gas. So that's why the market still exists for bilateral with you. Am I thinking about that right, or do I have?
That's correct, Your Honor. But I think again we run into the situation where the criteria that Tennessee has fixed they're not stagnant, or they can change them.
Yeah.
And so they could also continuously make changes to the criteria for participation in their pool and eventually figure out how to make it the most possibly appealing option for customers who will turn to that administratively efficient service rather than continue to pursue bilateral agreements. But all the while, you know, any circumstance where Tennessee is established what is essentially a false, meaningless standard for what is good, we'll still be driving ahead. But there's no guarantee that due, again, to this disruption in the market, that others will do the same.
So to bring this back to standing and concrete, imminent, particularized injuries, it seems to me that there are customers out there who want A+ gas, and that's who you're selling to right now and paying a premium for A+ gas. And so you're speculating that if there is this lower standard that is set by Tennessee Gas, some of your A+ customers will go there. Isn't that speculative? Because if they're motivated enough now to pay a premium for A+ gas, as the chief judge said, maybe they won't go to the pool. They'll just stay in bilateral transactions with you. And so aren't you speculating? And then you also said Tennessee can change this at their will, this, that, and the other. Again, speculating. We don't know what they're going to do. And in the past year, none of this has happened.
I'll try to address all of your points that you just raised there, Your Honor. First of all, again, it might still be that customers decide that they want to pursue bilateral agreements. It's unlikely, though, that given the option between a administratively efficient, federally approved service.
But these are the people who are willing to pay top dollar for your premium A+ gas.
And those customers do exist, but there are definitely also other customers who will still choose the easier, less good option, and that harms us nonetheless if we lose any customer base.
Bought your gas. Maybe they'd have bought the B gas.
That also is somewhat speculative, Your Honor.
It's all speculative, is my point.
But it's sufficient that the harm be substantial and imminent. And again, given that we are already market
how is it
leaders.
substantial and imminent? And concrete, I guess concrete is the word I'm looking for.
I think it comes back again to we are not speculatively involved in the market. It's not a question of whether we will or will not be.
Well, you're in it, but the effect on you is speculative.
The effect.
It depends on what these customers do, and you're assuming they're going to do something that we don't know they're going to do.
Well, that's true of any market, Your Honor. But I think it's reasonable to expect that customers will behave somewhat rationally and will adopt the advantageous or the efficient and the government approved option rather than continue to expend the time and effort to enter into bilateral agreements. I see my time is up, so if there are no further options, I'll request simply that you vacate and remand for orders below. Thank you, Your Honors.
Thank you, counsel. We'll hear from the commission now. Spanta.
Good morning. I'm Carol Bansett for the Commission. I suspect I'll spend much of my time on the merits, but I would like to make just a few brief points on the standing questions. We submit that both opening briefs fell well short of petitioner's burden. They both spilled a lot more ink on reply, which this court routinely finds to be too late. Antero introduced an entirely new argument in its reply brief on the procedural injury, which is why we have not had an opportunity to brief that. And in our view, both parties' tardy efforts still fail to satisfy their burden under this court's standards. With that said, on the procedural injury, as I said, it's newly raised on reply. The cases involve something like an environmental impact statement, a hearing, ex parte communications agency procedures. And I think the court is right at getting getting at that the argument here is about the merits. So this procedural injury theory of standing that is really about the commission's merits determination would seem to swallow the standing argument entirely, because I can't think of any case where that wouldn't be, where that same argument wouldn't come into play, that somehow the commission's merits decision, if you assume that the petitioners are right on the merits, then there's a procedural injury and we don't have to talk about standing anymore. As far as EQT, I think that the court is right that it's just speculation upon speculation upon speculation. Much of it added in the reply brief because it was just glanced upon in the opening brief.
How speculative is it though? I mean, because uncertainty is not the same thing as speculation. I mean, we say that injury is sufficiently traceable and redressable all the time when we don't know for sure what's going to happen. And I think their position is, look, we're better off in a world in which there are two options rather than three. The two options being you have the non-certified gas that's always been there and you can pool that too. We don't care that's out there. We're only looking at the market of potential consumers who really care about it being resourced in the way that is environmentally conscious and the most environmentally conscious. And as to that, we're just better off in a world in which the only option is bilateral. Which
Still is that world, because no one has used, at least as of the July 31st report, and I'm not aware beyond that, but I haven't heard otherwise, that we're still talking about a world of bilateral transactions. I do want to, this may introduce confusion and I may not be in a position to completely explain it. Bilateral transactions can be scheduled through paper pooling as well. Getting into the mechanics of that, I'm afraid I get beyond my own skis pretty quickly, but the bilateral transactions, which are the only RSG sales happening still, can actually be happening, doing the scheduling through the paper pools that exist, the non-PCG paper pool, because nobody's using the PCG one. So
I don't understand. I guess maybe I missed something that's obvious, but I thought the whole point of pooling is that you're not in a bilateral transaction.
I think it can be both. I think you can aggregate it there and aggregate different supplies and there's more flexibility there, but my understanding is that you can also schedule bilateral transactions through that same paper pooling service.
Okay, but then what they care about is, then that's sort of like saying, well, there's bilateral, and then you could use this mechanism called pooling to just do the bilateral too. That may be true, but then the point is that you can also do the pooling mechanism to do something other than bilateral, and it's the existence of that.
But the effect on prices is wholly speculative. Not just because nobody's using it, but even the commission didn't take it as a given. The commission said that the pipeline says it wants to offer this to its customers because there clearly is a bilateral market so far. And we think some parties might be interested in the pooling. The parties interested in the pooling, well, the customers are interested in it for their own reasons. And that does go to causation and redressability, because it really is third-party decisions driving this. The customers have their reasons for being willing to spend more for this gas, and the producers have their reasons for wanting to spend more to produce it because they think they can make the premium prices. None of that is given. None of that is in an affidavit or anything in this record. The commission, when parties raised the issue of price premiums, the commission said it's premature because we don't even know. I mean, we're willing to allow Tennessee to offer this option to its customers, but we're not even making a finding that the premiums necessarily follow. So even the premium pricing itself is speculative. All we know about premium prices is what producers have been able to get through the bilateral transactions, but we don't know what this PCG pool what customers it might draw, what producers it might draw, what prices it might produce, what effects that might have on other producers doing bilateral transactions. It's all entirely speculative because it just hasn't happened. And the commission, I'm looking in particular at JA 92, the tariff order, paragraph 20, in responding to an argument from the amicus in this case. Any concerns about potential price premiums at this point are premature. And then it goes on to say would not affect a shipper's ability to obtain jurisdictional pooling services. And that brings me to the first point that I'd like to make on the merits.
Can I just, before we go to the merits, just so I understand this. So let's suppose you have a world in which there's only one way to do, I'm going to get the acronym wrong, RSG, PSG, what's there?
They seem to be similar. We
Okay.
try to avoid the acronyms anyway, so I'm happy
Okay.
to just say certified gas.
Certified gas. Okay, so right, there's only one way to produce certified gas. So you don't even have a difference between A+ and B minus and C. There's only B.
Okay.
That's the only thing that exists. And we know that there's a bilateral market in which there's people who are buying the B gas because they want to have the certification.
Mhm.
And then the idea is, okay, well, then we're also going to create a pooling market because there's going to be certain efficiencies realized by that, because maybe you're having a bilateral transaction in a one-on-one way, but it could be much more efficiently done on an aggregate basis if you allow pooling. It's all the exact same thing, but you're just allowing access to a greater number of producers of the certified gas. If that's true, then if that's the state of the world, then what's speculative about the fact that there's a premium out there for the pooling? Because we know that there's a market for through the bilateral market. We know that there's people who will pay a premium in order to get certified gas. We also can know that pooling generally is something that people desire because we already have a non-certified gas market in which pooling is something that people use. So if we add that pooling component to the certified gas, and we just assume that everybody's producing the exact same certified gas, what's speculative about just knowing that, well, people apparently want to have certified gas, people apparently want to have pooling. So pooling into the certified gas market is something that seems like a good idea, and it's something that the producers of the certified gas will benefit from because they'll have a greater ability to reach consumers in an efficient way.
Right, but what effect it might have on diluting EQT's prices is still entirely speculative. Because all of that makes sense that there should be a market for this and someone should be willing to pay for it, but we don't know that. We don't know what they might be willing to pay. We don't know that the customers wouldn't still differentiate between this B pool and the A+ gas that they believe they can get on a bilateral basis from someone. So we don't have any numbers attached to the idea that there might be premium prices. There was an expectation by various players in the industry that there would be. The commission said, we don't know. We think that's speculative. And since this isn't even in our jurisdiction, it's not for us to say. What happened here is that Tennessee thought that there was an opportunity for it to serve some of its customers with a more flexible, or actually not more flexible, because to be clear, everyone has access to the same free scheduling service and the same paper pooling points. So the flexibility is the same in that regard. This was an opportunity where pipelines often come to the commission wanting to add or tweak their pooling and paper pooling services. It's not altruistic. They want to attract those customers. There are numerous pipelines that run into these different concentrated production areas, and they all want to get producers use our pipeline, ship your gas on our pipeline. So they all want to offer flexible pooling points and pooling options. And when pipelines come into the commission and want to add something to their tariff that they believe will better serve their customers and better attract those customers to them, the commission it generally approves those kinds of flexible additions to their service, with the number one concern being, does it take anything away from existing customers, especially existing firm service customers? That was a non-issue here because the commission concluded this changes nothing for any existing customers. It's the exact same service. And in fact, the commission viewed this and characterized it as an option within the existing pooling service. And it is specifically, I think it's rehearing order 18, I can check, somewhere around 16 or 18 in the rehearing order, actually rejected an argument by someone that it is a separate service. It is the exact same service with effectively an organic label attached to it. It's just a different, you might be selling, I could get lost in the metaphor there.
It's the exact same service as the pooling service that was already available?
Yes, it's free. It's the same pooling points. It's voluntary. So it is the exact same service.
There are heightened criteria for entry, right?
It's the same service. It's the heightened criteria to get a label that you can stick on it, but it's the exact same service.
With the heightened criteria for entry.
With a different criteria, but the commission said not for entering. The commission didn't view it as a separate service. It viewed it as a label. an informational feature is what it called it. It's a marketing label that you could get this label that you could attach to it, which you could also get on your own in the.
What if it had been the first pooling service? So imagine a world where there's only bilateral trades. And then Tennessee Gas says, well, I think it'd be great to have a pooling service for certified gas. And so they get FERC's, they file a tariff, they get FERC's approval for creating this service. I think you would recognize that's a service. And they say, the criteria for entry for this service will be put on our website. We can change it whenever we want, as long as we give 30 days notice. Would that be okay?
Well, it depends. Are you talking about the PCG criteria? So it wouldn't be for anybody but PCG?
Yeah.
I think then, because no one else is able to get this pooling service, I think that the commission would find that, likely find that unduly discriminatory. But the fact that everybody can access the
Why would
same,
they find it unduly discriminatory?
because you would have the non-PCG producers wouldn't have access to pooling,
In the same way that they don't have access to this PCG pooling service.
but they have access to the pooling service.
They have access to a different pooling, a separate pooling service.
It's not separate. They have access to the same pooling service,
Okay, well,
but not the label.
I don't want to get hung up on the labels and argue with it, but
Well, we're using label but it is an informational feature. The commission did not see it as a different service because it is the same
it is a
scheduling service from
where
all the different
trades are
points,
possible.
as it is in the regular pools. The
But
same
not
pooling
everybody can
points.
trade.
You can trade at the same point and get the same service, but you don't get the label. You don't get the informational label that this has a certification from Project Canary or the other
Even the
one.
dirtiest producer of gas can trade in the PSG pooling service.
They can trade at the exact same pooling points at the exact same rates and get
It
the,
just sounds like two different pools.
well, the commission didn't view it that way. It viewed it as a label.
That's why we're here.
Well, yes, but the commission does get some discretion on this kind of issue when it looked at whether it significantly
Its
affected.
discretion depends on pointing out material differences between this and our precedent that says when you do this, it's a pool. And labeling it an informational feature is not a substantive material difference. It's a label.
It is because these all
Just a
of
label.
the scheduling service and all of the pooling points is the same, are the same.
Can I ask this question? Maybe it's a way to tease out whether it's just labeling. Maybe it's totally off, and just tell me if you think it is. But suppose that for some reason there's a market out there for buying gas from producers whose corporate name starts with the letters beginning A to M, and just don't want to buy gas from anybody whose letters are from N to Z. And if the commission allows, and there's pooling out there already before it turns out that there's this emergent market of people who only like initial letters in the alphabet as opposed to latter letters in the alphabet. And then the commission says, okay, apparently there's this thing out there. So we'll allow there to be a pool that's limited to producers whose names start with A to M. And we'll allow that pooling product to exist. We're not going to monitor when somebody decides whether their corporate name begins with A, B, C, or M, or Z. That's up to them. They can figure out. Apparently buyers care about that. So we'll just let that happen. We're not going to police the criteria at all. We're just going to allow this separate market, this separate pooling product to exist. Is that similar to the way the commission is thinking about what this is, or is that hypothetical just totally off?
As long as we're saying that N through Z still have access to all the same pooling points and all the same transportation, same rates, charges, terms,
They do,
everything.
because it's
And
only
it's just a
just a
label.
convenience for those consumers who care whether your name starts with A, B, or QZ.
I think that the commission, unless you can find something discriminatory in it, if someone were being denied service, if suddenly the companies that start with P don't get to use the pooling point number 19, or we're somehow.
Right, they still have access to all the same pools. They're
It's just
by
a label.
definition not going to
It's just
have
a label.
access to those consumers who care about the fact that their name starts with P, with whom they wouldn't do a bilateral arrangement anyways because their name starts with a P.
Right,
Just that they want the benefit of the pooling,
yeah.
but they want to be able to differentiate based on a criteria that the commission, by hypothesis, just doesn't care about.
Right, and I think that the commission would say that it doesn't significantly affect the service under the Natural Gas Act.
Commission would just view that, even though there is now a different pool, because there's a pooling product for only A to M
Well, there's a label
Producers.
that those customers would see, but as long as all the terms of service are the same and no one is being boxed out or charged something different,
And to be clear, the buyers who care about A to M are willing to pay a premium for that because for whatever reason, they really care about it.
right?
Is that the way
Yeah.
the commission's viewing this? That we don't care about the preference. We don't, but apparently some people have the preference. And
Yeah,
pooling's a good thing. So we're just allowing a pooling mechanism that allows consumers to give effect to their preference.
I
But-
think that's right. It's not that the commission doesn't care, but the commission said, well, the commission does say we don't have jurisdiction to,
Right.
right? So I
Something
guess it's
that we don't
kind of
care.
like saying we don't care. Yeah.
We can't.
Yes, we can't care. I think that's, yeah, as long as, again, the main thing it's saying, the commission was looking at, does this significantly affect the service? And if they're still getting the same service and it's not harming anyone who already had the existing service, if it's just a label added on to the existing service, then I think the outcome would be.
I mean, there's still a
Same.
pooling product out there to which it's a new pooling product that didn't exist.
It's just a new label, but all the service that you get is.
When you say service, you mean transportation service? What do you mean by
Yes.
service?
Well, with pooling in particular, it's scheduling. It's, and I don't fully understand how that works, but it is the sort of administrative, like scheduling how it's, I think for accounting, it's sort of the gas is from this point, even though it really was from a different receipt point. But, and then of course, there is also the transportation service in the pipeline, which isn't even an issue in this
Right.
case.
But for
'cause
our
it's the same.
purposes, when we're looking at what needs to be included in a tariff, we're looking at things that significantly affect rates, charges, and service. And when
And
we're talking
service.
about service, we're talking about the service that FERC has jurisdiction over, which is the transportation.
Yeah, and here
gas.
it's part of the, it isn't physically
In the
moving the
schedule.
molecules in the pipeline because that is
Mhm.
part of their transportation service. That's not an issue here. It is the paper pooling points, which are just an administrative kind of a fiction of like collecting all the gas and saying it's at this point virtually. So yeah, it's
So I'm only
just the
asking this
scheduling. Yeah.
because something like, what is the quality of the molecules in the pipeline is something that affects service broadly defined,
Well,
but
yes.
it's not what service means to FERC. because
Well, it is actually,
Is it?
well, gas quality
I thought
standards.
That was part of the tariff. I thought that was part of a tariff. I could be wrong.
Gas quality standards are a very different thing. They're not about producer certified.
FERC regulates that all the time.
Yes, it has to.
So what's
because-
the difference between
Sure.
producer certified and that?
Sure. All the gas that goes in the pipeline has to meet whatever that pipeline's gas quality standards are, which is why it does have to put those standards in the tariff because it can deny you access to putting your gas in the pipeline. Now that's what percentage of this natural gas flow is a liquefiable hydrocarbon like butane or propane, because if it gets cold and those condense out, they can obstruct the pipeline or corrode the metal. So gas quality standards are the physical properties of the gas that is being transported. Producer certified gas is entirely about what happened at production in terms of, well, specifically here, it's about the methane intensity. It's about the methane emissions from the production of the gas. That happens at the well, or the facilities near the well. But that gas, when it's delivered to Tennessee, has to meet the same standards for butane, propane, whatever.
So it's not the gas, it's how it was produced.
Yes, so it's a label about how it was produced, but there can't be any dispute in this case that the gas going into the pipeline is physically the same, with the same low levels of liquefiable hydrocarbons that could actually hurt the pipes.
So FERC doesn't have jurisdiction over production of gas.
That's right.
And so when you talk about services under this statute, it cannot relate to production.
That's right. That's right. So
So
when
it
we're
doesn't
talking,
affect services in the sense that we need to look at it under the statute.
right,
It's about production.
because once they're transporting gas to the customer, it's like all the other gas. And it has to meet the same standards for the liquefiable hydrocarbons that might be in it. And whatever happened at the wellhead with regard to methane emissions is important to some customers, and there are certifications for that. But the gas that's physically being transported is exactly the same. And that's why the gas quality standards are an entirely different thing that are FERC jurisdictional, because they are about the pipes and the gas stream moving through the pipes. And this is about how was your gas produced before it got to that point.
And why does FERC exercise jurisdiction over the pooling, the availability of pooling to begin with?
Because it does
At
have,
least one of the petitioners say, we don't care if FERC decides just not to get into that mix. And then, so it's out of the ballgame altogether, both as to that and as to the criteria. But the problem is that FERC's drawing a distinction between making available the pooling option and regulating the criteria. So they have
well,
to be, they have to
I
be-
mean, I think they still want access to the pooling points for getting their gas. It's sort of,
well, not for certified gas, because they only produce,
well, but they still have to get it to their customers and it has to get to the pipeline somewhere. And that involves the pooling points. It may or may, I guess maybe they don't want to aggregate it with someone else's and look for their customers there. But pooling points, both physical and virtual, have a lot to do. This, I get kind of hazy here, but the gas has to get from the well to the interstate pipeline somewhere. And it interconnects at certain points. But my understanding, at least, especially with paper pooling points, is that we kind of create I hope I'm not getting this wrong, but I hope we create a fiction that says this gas came from here. Really, it came from here. It had to get to here for purposes of prices and everything, the transportation rates in particular, but I don't even know for what else. But we're going to say it started here because you've got a whole spider web, or maybe more of a radius kind of thing of pipelines. And we have to say the gas started from some point. So we have these pooling points that collect the gas from different parts of the production area.
so even though,
That's my
in other words,
understanding.
even though it's virtual, we treat it as if it's actual physical transportation. And that's why.
Well, we treat it as, since it is in relation to the transportation service, we do treat it as transportation under the Natural Gas Act.
And that's why the agency asserts
Yes.
dominion over that part of it, but then doesn't assert dominion over the criteria.
That's right. And even with paper pooling, I think, and I believe Intervenors Council has some cases on this, that we don't even necessarily, in some cases, we haven't necessarily required the exact pooling points to be in the tariff. We've allowed that to be on the website too. Where the commission really requires things to go in the tariff is when it's going to deny you access, potentially. If it's something that is going to deny someone access, it might be the terms in which interruptible service can be interrupted. It might be moving an entire pooling zone or changing a pooling zone boundary. Those kinds of things, those are the cases where the commission has said this has to be in the tariff. Because the producers and the customers need to know that the gas can get into the pipeline, or what are the terms, they need to know in advance, what are the terms under which we're going to be denied. So those cases have been about getting access to the pipeline, and that's what's different here. There's no denial of access to the transportation services. There is an informational label that you may or may not get from the pipeline's criteria. You can, of course, get your own certification.
Wasn't that true in Columbia Gas and other cases where a pooling service was being created, and one argument that failed was, well, nothing is really changing here because you could always make bilateral trades. The same, everybody has the same access to the pipes, whether they want to do bilateral trades or whether they want to be in the pooling service. And we said, no.
No, because scheduling is a service too. And that's where I was saying if
If scheduling is a service, why isn't access to the scheduling service?
Because everyone still has access to scheduling. It's like I was saying in response to the A through M, N through Z. As long as the producer that begins with R or the shipper that begins with R can still access the service and have the exact same terms. Same
Tennessee
service.
Gas had an A through N pooling service, and they said to everyone, this is an A through N pooling service. And then it turns out they actually allow QRS. Would the A through N producers have an injury, and would they have a good argument that
I think that we don't even allow that as long as N through Z also had access to the same, to
That would be fine.
scheduling service. I mean, they
that would
can't,
be fine with FERC?
if we had said that it wasn't something that has to be in the tariff because it doesn't significantly affect the service, then I'm not saying
That's
that,
begging the question. But imagine
Yeah,
that Tennessee Gas creates the chief judge's hypothetical, an A through N pooling service. And it says, but we're going to put the criteria for entry on our website. And it starts out saying A through N. And then later it changes it. And it says, this is still an A through N pooling service. This is for customers who want to buy A through N. But it turns out that they're allowing QRS on there as well. It seems to me that the A through N producers who had a good thing going and now have to compete with the QRS, number one, would have standing, but then you agree with that?
Oh, they'd have standing in some kind of case, but I don't think it would be a Natural Gas Act case.
Okay, put a pin in that. And then do you agree that would be kind of something that FERC would not allow?
Again, if those criteria weren't something that significantly affected service under the Natural Gas Act to begin with, I don't think they'd have a FERC case.
Well,
I'm not saying they wouldn't have some kind of recourse against the pipeline, some tort or something, but it wouldn't be a FERC.
No, please.
So I thought put aside standing, because the reason I think this hypothetical is illuminating, at least for me, is because it goes to the merits, the agency's flexibility on the merits. So let's put aside standing, and then Judge Walker's hypo. I thought that your answer on whether the fact that Tennessee allows QRS into this nominally A to N pool is something that FERC would care about. Isn't the answer no? FERC doesn't care about that. I mean,
No, I meant to say no.
Otherwise, I
right.
don't know how you can defend what's happened with the criteria in this case, because here, if it turns out that Tennessee has some criteria, and then those criteria are just being mismanaged, and the label turns out to be false, that's by dint of FERC's not exercising jurisdiction over the criteria.
Because they didn't significantly affect the service, it
Right.
still wouldn't significantly affect the service.
Right. So
Right.
I think you have to be comfortable with the notion that at that point, nobody can come to the agency and say, hey,
Right.
step in here.
I'm sorry if I didn't, that is what I meant to say. I mean,
I just want to
thought
make
it
sure
said
that,
yes.
if I'm understanding the hypothetical correctly, that's FERC's position is that, no, this is just something that
Doesn't,
that's out there for you all to work
it
out.
doesn't significantly affect, right, that's exactly right.
So if we were to disagree with you and remand this case, then there would just be no pooling service for PCG, right? Because one of the petitioners said we should order you to assume jurisdiction over this, which I think the more correct thing would be just to remand and say what you've done is not consistent with the act or whatever. And then you probably just would not allow the pooling service because you're not going to.
Based on the orders here, I believe that would be the outcome. If this court said that notwithstanding the commission's discretion, that this case is somehow more like Keyspan Ravenswood than it is like the Public Service Commission of New York or City of Cleveland. If it's Keyspan Ravenswood and the commission has to say this significantly affects service, then I think it likely would say no. The only reason I even hesitate is because in the earlier order, the rejection order, I think it was April of 2022, the commission in that case, when Tennessee had included the criteria in the filing, the commission said, we don't even know how we would judge this. The pipeline haven't given us any basis to judge this. And it did say in a footnote that if there were industry imposed standards or standards imposed by someone else, whether it's some other federal agency or the industry had come together and said, this is our standard. And Tennessee just wanted to put that, comply with those standards. I think the commission indicated in that case, we might say, this is okay because it fits those industry standards. I'm looking at JA 346, it's footnote 13 in that order. So that's the only reason I even hesitate, because certainly the commission is not, based on these orders, the commission is not looking to suddenly say we can regulate this and make our own decisions about it. But whether they could somehow get it in based on this, I don't know, based on that footnote.
That's two, I think, quick questions and maybe yes or no. Could Tennessee Gas list its quality standards only on its website and change them whenever it wanted to?
The gas quality standards? No, there are numerous cases. I think they all are called indicated shippers. They're cited in our brief and in the orders that because that is something that can deny they can turn away your gas and say you're not coming in. That has to be in the tariff because that goes directly to service.
Okay, and then second, let's say we disagree with you about whether this new pooling thing is a service. I know you don't want us to disagree with you, but let's say we decide it's a new quote unquote service. At that point, do you still contest that the criteria governing access to the service significantly affect that service?
Yes, because even if it is a service, the commission, because the rates and the scheduling service and the pooling points are all exactly the same and the label doesn't affect any of those jurisdictional aspects, I think that the commission would still say that the criteria could be on the website instead of in the tariff. And now if the option had different pooling points, instead of the 20 that we already have for everyone, which you can also use for that, if it added 21 and 22, but these are just PCG points, then we've got a whole different story, and they wouldn't be getting the exact same service. Or if we, I think, well, yeah, I'll leave it at that.
Okay, thank you,
Thank you.
counsel. We'll hear from interveners counsel now. Mr. Corman.
Thank you, Your Honor. Thank you, Your Honor. May it please the court, Paul Corman for the interveners, Project Canary and Tennessee Gas, but based on the questions, I think I'm here mostly for Tennessee Gas. This is not a new service, okay? The best way to see that it's not a new service is to refer to JA 18 and 19. Those are the redlined tariff sheets that Tennessee submitted. Those are the pages that specifically identify the pooling points. You will notice that there are no red lines in the identification of the points. There are no points added, no points subtracted, and no points are changed. The only red lines you'll see on those pages is a very short reference that says these are the same points as for the PCG service as they are for the regular service. So there's no difference in the pooling at all. This is not completely divorced from the tariff. The tariff references the EBB posting in two places. In the tariff section itself, in section 2.3B on JA 15, and then in the form of service agreement, which is also included in the tariff on JA 22, they both reference the EBB as the place to find the criteria. It's very similar to what this court found acceptable in the Hecate case. I hope I got that right, Judge Walker, in where the court was satisfied because the commission exercised its discretion that something didn't need to be in the tariff, but you could find it in the tariff where to go look for it. So I think it's very similar. It's very similar to Hecate, the points are the same. So let me talk about how the pooling actually works, because there were a lot of questions about that. And I'm not a scheduler, but gas can come to these pools from various places as a scheduling convenience. Tennessee's just a transporter, and all the commission regulates is the transportation. But because you have this aggregation of gas at a similar point, people can buy and sell their gas. They can buy and sell their gas, and they do bilaterally, okay? So today, tomorrow, however long they want to, EQT can say, I have the cleanest gas out there, you should pay me a premium, okay? They can do that today, they can continue to do that. Then the gas, leave the PCG aside for one moment. The gas is aggregated. The shipper who has title to the gas is going to move the gas, nominates it on Tennessee's system, and the gas is then transported to wherever the end user is. All that happens with this service is there's a piece of paper, an informational feature, a bolt-on that says the gas that producer X delivered into this pool is responsibly sourced gas, is PCG. So a buyer who cares about that can say, okay, I'm going to buy it from that person. And I'm going to have that person I'm going to have that gas transported on Tennessee. But, as the 28J report indicated, currently, nobody's using the service, and I can represent to the court that that remains true as of Monday. And I think, to switch off to standing for one moment, all of the harm, well, the word harm appears in the briefs multiple places, but they don't say where the harm is. Where is the concrete injury? Where is the certainty that something is going to happen? Everything is, well, if other pipelines adopt different standards, the market will fracture. Well, that's an if. That hasn't happened. If local distribution companies like Tennessee's standards as opposed to something else, well, my guess might be worth less. If state commissions give some credence to the Tennessee standard, then my guess might be less somewhere else. It's all a series of conjecture of the type that this court has found inappropriate in standing cases in the Kansas Corporation Commission, Florida Audubon Society Commission, all of which are cited in our brief. So I do think that the standing goes to all the various ifs.
There was a time you thought this was a new service, correct?
We've always referred to it, we really always refer to it, I think, as an information feature. I think they
I'm
might
not
have
even talking
said,
about labels. Again, I'm trying to not dwell on the labeling. I thought that you filed a proposed tariff with FERC that said, here's a new service and here's what the criteria for certification will be.
it's an add-on service. I mean, I hate to say this, but some of this is advertising, Your Honor. And it's substantively, it's really the same service with a piece of information,
Then why did you go to FERC and say, I need you to approve this proposed tariff that has the criteria for certification in it?
Actually, Your Honor, at the beginning, the first filing, the company proposed that the criteria be on the EBB. Subsequently, a number of the
What's the
customers,
EBB?
Electronic Bulletin Board. I'm sorry, where it is now.
Website.
The website.
Okay.
Sorry, old name. Subsequently, a number of the customers complained and said, we think it ought to be in the tariff. So the company was customer friendly. We filed to put it in the tariff. Okay. We brought it to the committee, we went to the commission and the commission said, no, we don't. The commission does not think it belongs in the tariff because it's a characteristic of production, which we don't regulate. It's just an information feature. So take it out of the tariff and there we are. Okay. I wanted to get to your question about the gas quality a few minutes ago. I totally agree with counsel for the commission. It's an access issue. In a number of those cases, which are all indicated shippers versus somebody, the commission was very clear that one of the major problems was the pipelines in those cases were trying to use postings on their website to override the tariff. That's not the case here. Okay, we have a tariff provision. The tariff points to where to find this on the website. And we think this is well within the kind of discretion the commission has to determine what should be on the website, what should be in the tariff and what should be on the website. This is certainly of less significance than the items this court upheld in City of Cleveland and Public Service Commission of New York, which are cited in everybody's brief. Those were cases in which the criteria that was not in the tariff could control access to the service. That's not the case here.
Thank you, counsel.
Can I ask you a question?
Okay.
Why do you think nobody's using the service?
Why do I?
Yeah, why is nobody using the service?
I'm not a gas trader either, but I think they're doing bilateral transactions for all we know. I don't know. I don't really know.
Thank you.
Thank you, counsel. We'll
Thank
give each of petitioners, counsel, 2 minutes for rebuttal. Ms. Taylor first.
Thank you, Your Honor. First, I'd like to speak to this idea that this doesn't affect the actual transportation and that it's therefore somehow something that FERC is entitled to be agnostic about. If you read the Coke Gateway FERC decision, it talks about FERC's policy, right? They actually had, it was Order 636, I believe, although I could be wrong about the number, that they don't want pipelines to create obstacles to pooling. This is something that the commission cares about because pooling facilitates the market for gas. So the idea that it has to block physical molecules from entering the pipeline itself before it's something that FERC as the economic regulator should be concerned with, I think is just not sustained by FERC's own past writings in this area. Then to speak for a moment to hypothetical about the companies with A through M, I think that an important distinction here is, that everyone at the outset thought, companies that start with A through M, their gas is going to be valued more highly. Everybody thinks there's going to be a premium for this gas. And in fact, in order to obtain a company name with A or through M as the first letter, you have to invest millions of dollars in getting a certification that you qualify for that. I don't think that under those conditions, FERC, again, as the economic regulator of the pipelines, is entitled to just take a step back and say, well, we don't really care if people are later going to be able to say, well, my name starts with Q, but I'm going to put myself in the A through M pool, and then there's not going to be any FERC oversight there. The other point that I'd like to make is that even if this is just an informational feature, or we use some other semantic label to describe it, or this court agrees that it's an add-on to the existing service, it still significantly affects that service for these same reasons, right? There's an economic premium that is associated with this gas. There's also an economic premium associated with the liquidity, right? Everybody says this is going to make it easier to do these trades. And so at that point, whether you call it an informational feature or a new service, it significantly affects customers' access to these pools and the premium that they may or may not be able to access there.
Thank you, counsel. Ms. O'Neill, we'll give you your 2 minutes.
Your Honors, I'd like to speak to the idea that these are the same service. They're not. They are two separate services. And I think there's a couple distinctions that are important to keep in mind when we're thinking about that. First of all, again, these criteria exist that govern access to the producer certified gas service. Those criteria are not applicable to the general pooling service, which is available to any shipper that requests it. And I think perhaps more tellingly, I know that counsel for Tennessee Gas pointed to the red lines in their tariff. JA 15, that's the beginning of those red lines, that shows the parts of the PCG pooling service option that remain in the tariff, although the criteria have been bifurcated. And provision 2.3 subpart C introduces independent audit and enforcement criteria that are specific to the producer certified gas pooling service. Those do not apply to the general pooling service. And that is just another aspect of what differentiates. Again, it sets us apart. The producer certified gas pooling service is a separate idea from the general pooling service that is governed by these criteria that FERC does not have the jurisdiction to, or the expertise to evaluate. The second thing I want to touch on is your question, Your Honor, about why no one has utilized the service. This service has been litigated now for over a year. It's reasonable in that time that parties might want to wait and see what's going to happen. Tennessee Gas obviously still thinks someone's going to use this service and that it has value. If they didn't, they wouldn't have proposed it from the outset. They wouldn't have come back in the second docket, and they wouldn't still be litigating it here. There are parties in the market that see this service as having value, and as long as that is true, that it stands to potentially harm the premiums available to participants in that market. Thank you, Your Honors.
I will.
Yeah.
I know it's been a long argument, but I am, part of FERC's purpose is to, encourage efficiency and fairness. And, a regular pooling service, everyone in the room agrees, serves purpose. And if you're right, then there will not be a pooling service for cleanly produced gas. And what that means is, of course, yes, there'll still be bilateral trades, but there'll be fewer trades if it has to all be bilateral than it would be if there's a pooling service for this. That's the whole point of a pooling service, to increase the number of trades, make trading more efficient, I think. So assuming that every trade has a gain for both sides, how is this consistent? How would it be consistent with FERC's purpose and mandate if at the end of the day, what we're left with is a regime where there can never be a certified pooling service? And that means a lot fewer trades, which means a lot fewer gains from trade.
Your Honor, although in an aspirational higher realm of thinking, we would want to encourage those trades, again, to increase movement of producer certified gas and drive the market towards the lowest methane intensity product. The fact remains that those areas are not within FERC's jurisdiction. So although it's within their mandate to, protect customers on these pipelines and oversee transportation service, it's not within their statutory mandate to encourage any specific economic outcome or wade into the commodity markets, which I think is getting at what you're describing.
Okay, thanks.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 22-7038, Citizens for Responsibility and Ethics in Washington, appellant versus American Action Network. Mr. McPhail for the appellant, Ms. Murphy for the appellee.
So it's still morning. Bill, please proceed when you're ready.
Good morning. This is an appeal dismissal of a suit that Crew brought against AAN, private suit, in which Crew seeks information which is entitled, which it plans to use. AAN is one of the largest dark money groups in the nation, spent over $150 million, $50 million in the last election cycle alone, to influence elections, buy favors, without disclosure of the sources of those funds in violation of law. We know those numbers are understatements. Crew's suit was not dismissed because of any legal infirmity in its theory or lack of evidence supporting its claims. Rather, it was dismissed because a minority of commissioners at the FEC stated that they were unwilling to let the FEC enforce the law here. There was no logical connection, of course, between that statement and the propriety of Crew's suit. Nonetheless, the court below found it had to dismiss his case following the decision in New Models. Now, the problems with New Models and its predecessor, CHGO or Legion, is recognized by your colleagues in this court, and we set out in a brief, but they also don't apply here for two reasons I want to focus on today. First, there is no contemporary statement of decision makers that is a touchstone for judicial review of an agency action.
Can you address Judge Millett's statement, joined by Judge Pillard in New Models 2, that the exercise of prosecutorial discretion here and the exercise of it in New Models were, quote, almost identical?
Yes, so that goes to the second point here, which is the invocation of prosecutorial discretion here is not the type that would preclude review under New Models. New Models is clear on that.
Maybe start with this question. Do you think Judge Millett was wrong?
I think she was wrong in focusing on the particular language that caused the prosecutorial discretion to preclude review in New Models.
Likewise, I guess you would have to say you think she was wrong when she said that the decision by the district court in this case highlights the consequences of the court's decision in New Models.
It actually highlights the consequences. New Model has been devastating in precluding any judicial review of any complaint brought dismissal after that case, because it has empowered a minority of commissioners to block review using, invoking factors that are could be true in every case. But nonetheless, in the concurring opinion in New Models, the court said, make sure that's right, that if the commissioners reference their merits analysis as the grounds for exercising prosecutorial discretion, that remains reviewable. Say again. Says if the commissioners reference their merits analysis as the ground for exercising prosecutorial discretion.
So New Models 1 said, which that's binding on us, not the concurrence in New Models 2. Mm-hmm. New Models 1 says it matters not whether legal interpretation underlay the decision. And that's because a commission decision that rests even in part on prosecutorial discretion cannot be subject to judicial review. And it adds that a common reason for failure to prosecute is the belief that the law will not sustain a conviction, and that type of decision in the typical prosecution context cannot be subject to judicial review.
And there what's speaking about is both the case CHGO, where in those cases, it's where a prudential decision is made that, for example, it's not worth the agency resources. And what is feeding that decision is a belief that say that the case is particularly complex or that there are statute of limitations problems that would limit the review. And those, the legal analysis merits are feeding into what is a essentially unreviewable decision about agency resources. And there in THGO and UL said you can't pull out from that prudential decision the legal merits analysis. But where all it is legal merits analysis, which is all we have in the 2014 statement. The 2016 statement nowhere mentions discretion at all. The 2014 statement defers to prosecutorial discretion. It says, quote there, moreover, the constitutional doubts raised here militate in favor of a cautious exercise of our prosecutorial discretion. And cites Heckler with the quote.
So again, and you're saying Judge Millett was just wrong when she said that the two cases were almost identical.
I think there was a distinction that the majority in new models, the concurrence draws out between the applications of those cases. And that says you cannot expand new models to a case to apply where just these two words apply.
So you think she was wrong?
I think it was wrong to say that new models necessarily controls the application in this case.
Okay, and let me give you a hypothetical. Imagine that a prosecutor, regular criminal prosecutor, indicts a defendant and then files a document withdrawing the indictment. And in the document, the prosecutor says, we invoke prosecutorial discretion because we think this is a weak case. And then it goes on for 20 pages about why we are invoking prosecutorial discretion, 20 pages about why it's a weak case. That would be not reviewable.
That is not reviewable because the action is not reviewable. A prosecutor's decision to prosecute or not prosecute is absolutely subject.
So what if the FEC did the same thing? They started the order. I recognize this is a hypothetical. This is not this case. But they start the order with, we invoke prosecutorial discretion because we think this is a weak case. And then it spends 20 pages describing why it's a weak case. At least under new models, do you think that's reviewable by this court?
That remains reviewable because the action review is a vote to close the case. And under Aikens, we know that is absolutely reviewable. The action is reviewable. The sole question new models introduces, and we argue, and I think other causes recognize in contravention of standard law, is that you can make an action unreviewable by discussing, by just talking about why you did it, which is what the statement here, it's an explanation of why they particularly, here they deadlocked the reason to believe vote. That's
Wait, I'm confused. Are you giving an answer that takes new models as a given, or are you giving an answer that says new models was wrong and therefore the answer to Judge Walker's hypo is that should be reviewable?
I'm taking new models as a given. New models rule, which we believe is in conflict, but this is the rule of the decision, that the action of closing the file is a reviewable action. But what is a reviewable action becomes unreviewable by the mere discussion of a minority of commissioners. Now, even that rule says the discussion has to be the discussion of prudential factors beyond a court's ability to review. Resources, priorities, those sorts of things that Heckler talks about. But if the discussion is based in law and merits, that stays reviewable, which new models says to try to reconcile.
Even if it's a discussion of law that then is tethered to a prosecutorial discretionary judgment that we're not going to go forward because we don't think the legal case is strong enough.
I think their prosecution is merely standing in for the terms of the merits legal analysis. You don't make what is reviewable legal merit analysis by calling it prosecutorial discretion. What they would need to do is sort of a step further, which I understand is sort of an arbitrary step, but this is the rule new model set out. You have to set out and say, well, there's legal problems here or legal analysis. That impacts our resources, and we don't think it's worth our resources, give them time hours or whatever they may have. And therefore making a judgment about the resources of the agency that courts don't have ability to review. And under new models, that's the rule because you can't review the resources judgment. That's why the court talked about them being an advisory opinion, that there would be this ulterior motive out there that would not be reversed by judgment of this court.
Well, there's still another category, which would be what you just laid out was resources that are also tethered to legal determination. There's another category, which would be resources that don't have anything to do with the legal merits and demerits. It would be that my office just doesn't prosecute cases that involve category X types of claims because I don't think those are important. I don't care if it's a meritorious claim.
Exactly right. So the second option there is essentially new models, where the court there it's lengthy analysis saying, this was not a political committee and we shouldn't enforce the law. There's no violation here. Also, by the way, a second reason we don't think it's worth our time. This is a defunct group. Other issues they mentioned there, and it goes through a number of reasons why this is sort of prudential. And it says therefore that's why prosecutorial discretion is two reasons. CHGO is the earlier case where it was actually sort of shoved together. And they said, well, statute of limitations probably run out here. This is an old case. So we are exercising our view of prudence about resources and agency priorities, not enforce. That's being informed by our sort of understanding of statute of limitations rule, which has now since been reversed. It's wrong on the law there. But that still informed that judgment. So CHGO said because it's informing what can't be reviewed, you can't prevent review. But New Models says, and it emphasizes in responding to the dissent there, it says the reason it blocked review here is because prosecutorial discretion isn't merely the description of the legal analysis. Prosecutorial discretion is an additional grounds. It emphasizes that and actually highlights that language and italicizes it in the majority opinion. It's additional ground there because there's an additional ground based in things courts can't review. That's why review terminates under New Models. You don't prevent review just by calling your merits analysis prosecutorial discretion, which is
Can
what.
I ask you a question about why we're doing all this in this proceeding? So there's something a little bit odd about a world in which all the stuff about whether it was reviewable happened in a contrary to law proceeding that's now over.
Yeah.
And then there's a civil action that's filed. And then we're re-reviewing the contrary to law determination that's already done. So it seems, but you bought into this because you're not contesting that that's what we're supposed to be doing here. But so if it went before, let's say this, in this case, it happened to go before the same district judge. But if the civil action, and I'm not aware, I could be wrong about this, I'm not aware of a reason why it has to go before the same district judge. So if the subsequent citizen action goes before a different district judge, then is the way we expect the system to work is that the second district judge double checks the work of the first district judge on the contrary law determination?
No, Your Honor, there's no authority to say that's what actually happened here. Now, I think under the rules, if the first decision had no jurisdiction, for example, so there actually was no valid order issued, then you wouldn't have the requirements in the FECA to exhaust, right? You need to have an order finding contrary law, failure to conform within 30 days to show exhaustion. That is a requirement to bring the citizen suit. So you have to have that. But as long as it's a jurisdictional decision, which I think there's no real dispute that these are within the jurisdiction of the court to offer, I don't know that there is no reason that the fact of exhaustion has happened, right? We received a judgment that's contrary to law. There's been a failure to conform. That exhausted our claim. We can bring the claim here, regardless of a legal error in the prior claim.
But you haven't made that argument.
Well, we've made the argument that the first, at least the very first claim is a dead letter because they went back on remand and reconsidered it.
No, but as to 2016, you haven't made the argument that I think, I wasn't completely following what you said, but you haven't made the argument that the contrary to law determination with respect to the 2016 statement is done and over. And so in this proceeding, all you have to do is look at the fact that that was a contrary to law determination. We don't second guess the merits of that contrary to law determination and whether the district judge got it right to say that it was reviewable. That's done. All we look at is the fact that it happened. And now the fact has happened, therefore there's jurisdictions. Therefore, there's nothing to be done here other than address the merits of the claim.
So you're right, we don't raise that in the briefs here. We did raise that below as an issue, obviously not presented here, partly for reasons that following other decisions and other arguments of this court, receiving the inclination to review the propriety of the underlying.
Why? Where are you getting that from?
That is in one of the CLC arguments. I don't remember which exactly one it was recently, but there was one about 6 months ago. And there's a question of whether they could pursue their private right of action against, I think it was Heritage in that case, perhaps. I
mean, I will say that if you're actually, you haven't made that argument here. You said you made it in the district court. Yeah. I'll take your word on that. It would be, I don't want to be too pejorative, but it'd be a little bit rich for you to make that argument here, even if it's meritorious, having argued in the contrary to law stage that AAN couldn't take an appeal.
No, the AAN can't take an appeal because the case essentially is continuing. So
but if you buy that, then what you'd be saying is they can't get an appellate forum on contrary to law determination the first time around because it's non-final. And then when it comes back this time, you'd say, oh, but they can't get an appellate forum now either because that's done and over. The fact that there was a contrary to law determination is on the books. That's all you look at. You don't look again at the merits of the reviewability determination.
Well, on that particular issue, which again, we don't put in this brief, so not defending here, but the fact that gives rise to this suit is not that there was a legally correct decision offered in district court that has no appellate issues around it. It's the fact is that there was a judgment and the FC failed to conform. FC could have appealed, it chose not to. So it started a 30-day clock to conform. That fact is what we need to exhaust to bring our claim. That allows our case to go forward.
Right, okay, you haven't made that argument in the briefing, you're making it now, and I understand why you're making it because I can understand why there's some merit to it. But you still argued, it seems to me to make that theory holistic so that the system makes sense, you would have to allow that AAN in the contrary to law determination could have taken an appeal of that. Because it's a lot to say the first time around when the correctness of the contrary law determination is squarely an issue under the argument you're now spinning out, you didn't spin it out in your briefs, but you're now spinning it out, and I appreciate that you're doing it because I asked you about it. But it's one thing to say that determination about the correctness of the contrary law assessment by the district judge is now over. If there in fact was an opportunity to take an appeal and then ultimately file cert petition if necessary, because every possible legal avenue is then exhausted. And then you can say, yeah, that's done and over. At that, we're not going to second guess that. We're not going to ask a second district judge to look back at that. After all, the DC Circuit affirmed it and cert was denied by hypothesis. So what's the second district judge going to do? Of course, you have to take that as a given. Now you only look at the fact of whether there was a contrary to law determination. There was, ergo there's jurisdiction, ergo we go forward. That seems holistically coherent to me. It seems tough to say, we went in and said to everybody, you can't take an appeal that first time. And now we're going to come in and say, that's done and over. The contrary to law determination is on the books. That's all we look at. So AAN never gets a chance to get a legal review of the correctness of the district court's contrary to law determination.
One, I think that's not quite correct. They would under in a legal challenge to the actual administrative proceeding, which is currently district court.
A legal challenge to what?
The administrative proceeding. So the contrary law judgments come out of the administrative proceeding where we filed a complaint against AAN. It was dismissed, we sued, it was went back down, we sued again, it went back down. It was then dismissed a third time now in 2022. That's a district court currently now. That case is a sort of continual line of cases where those decisions are interlocutory. If that proceeding goes up on appeal, that would be an opportunity for AAN then to challenge all those legal proceedings in that interlocutory proceeding.
You think that can go up? You think that's, why wouldn't you make the same non-finality argument that you made to deny an appeal now? To deny an appeal from the 2016 one?
Well, one, because those interlocutory decisions, I understand in case law that the decisions leading to a reversal and remand become interlocutory essentially in those proceedings. And so when a court remands a proceeding to an agency, if the agency is preserved, they then can do a legal challenge and then challenge any interlocutory order in that proceedings. That's obviously not what we're involved in here. So I apologize for maybe mingling the laws, understanding that law slightly. But this, and again, there's not an argument here, but the argument, as I understand you're asking about, is
in which you're agreeing with, I think.
Well, I think it's correct, is a view that
that means you're agreeing with it.
Yeah, that the exhaustion requirement here is solely a order and a failure to conform. So you can imagine an EEOC case, right? So the exhaustion here is to go get a letter from the EEOC with a right to sue. There's no right to appeal that letter. There's no right to challenge a letter, but the exhaustion has happened. You got what you needed to bring the lawsuit. And so someone can't go to court and say, you're not allowed to sue me because I couldn't take your right to sue letter to court and challenge EEOC and do all that stuff. It's just, the statute says there's a thing that has to happen. A real fact in the world has to happen before you bring the lawsuit. That thing has happened here. There's no dispute about that. Therefore, we've exhausted our claims and we can go forward. So I think if the court were inclined, that is a way for dispose of this issue and say whether or not they should review it under prosecutorial discretion, since it doesn't go to the jurisdiction of the district court, which the CLC cases confirm. These are perfectly valid judicial decisions. If they are wrong, the FEC could have appealed. It chose not to, essentially waiving its right to appeal. So it said the FEC's job was then to conform. And by choosing not to conform, that satisfied all the factual predicates for us to bring a lawsuit.
So can I ask you then, do you think it's appropriate for the district court in this case and now us to look at the merits of the contrary to law determination?
Is it appropriate for you to look at the merits of the contrary to law determination? I think the proper answer is no. That under the law.
But your whole brief is about us doing that, right?
Well, there's understanding if the court does look at the actual statements, then we're running a number of arguments to do that.
But you think actually you've briefed the case on an urging of us to undertake an inquiry that you think it's inappropriate for us to do in the first place.
Well, I think that it does not require for us to establish exhaustion or FECA. So even if the court does look at it, there's no reason that the court shouldn't think.
Yeah, you think you still win. I get that. You think you still win even if we look at it, but you don't think we ought to be doing this.
No, I think the exhaustion has been proven. We've brought a claim to the FEC. If you fail to enforce, we've received the contrary law judgments. The 30 days conform didn't happen. We've exhausted any ability we have to seek administrative remedy. So we should be allowed to bring our own lawsuit here. And again,
Do you think we have to address that question because it goes to jurisdiction? Or do we have discretion to say, because no party has argued to us until oral argument that we ought not look at this at all, we're going to assume that we should. And then I know you have the argument that we should still rule in your favor.
yes.
Do you think that we have that route available to us? Or do you think that because the threshold question of whether we ought to be doing this at all goes to our jurisdiction, that we have to address that? And based on what you're saying now, we should conclude that we shouldn't be doing this. You understand the question I'm asking?
Yes, I understand the question. I'm trying to think through all the sort of levels there. I don't think it goes to the Court of Appeals jurisdiction. So that'd be obviously district court and the Court of Appeals for any level dealing with the citizen suit.
But we'd be looking at whether the district court had.
Yeah.
We always have to assure ourselves of jurisdiction along the entire.
I think I apologize. I don't think I'm prepared to answer the questions. I'm not quite. I did figure out is whether a exhaustion requirement is a jurisdictional, bar that essentially by whether the ability to consider this exhaustion denies jurisdiction for the court to consider anything else beyond, it goes into the exhaustion. If I understand the.
And then let me ask one last question along these lines that circles back to something I asked earlier, which is, does it seem fair to say AAN shouldn't have gotten an appeal from the contrary to law determination the first time, and they also shouldn't get a chance now to argue that the contrary law determination was wrong?
Well, absolutely. One, there's a chance to appeal at the end of that administrative proceeding if that's where it goes, since that case continues. But two, it'd be like saying that a person, it's unfair to face a discrimination lawsuit.
I think I'm missing something very basic.
Can you speak a little slower?
Oh, I apologize.
I appreciate, that would be great.
I apologize.
Thanks.
I don't think I understand the route to an appeal that you see of some proceeding that's ostensibly still ongoing. What is that?
If, for example, we won Crew 1, it had been remanded back to the FEC, and the FEC had gone against AAN, and so brought a legal challenge to AAN. AAN could challenge the legal propriety of that action by challenging the prior interlocutory decisions in that order. And I think in this case, one of the USCA cases, I think, or maybe the NRC.
Why would they be able to do that? Because even in that, first of all, that's one possibility, but there's no reason that possibility would necessarily come about. Because what could have happened is exactly what happened here, which is that the commission didn't do anything, and then so a citizen suit was brought. And then the commission, I know the commission could still decide to do something now, but they don't. Let's just say they sit out. So AAN then is stuck in a situation in which they would have never gotten an appellate form. I mean, even if you're right that could have happened and that they could get an appellate form, they're not guaranteed one because it requires the commission to have come in and to do something, right?
Well, you're never guaranteed appellate form, right? I mean, if you win, you don't get an appellate forum.
Right, but when it only arises when you lose. And so the question is, are you guaranteed a chance to have an appellate form look at it after you lose? Typically, the answer is yes, but it seems to me that you're saying that here the answer is no, and that's still okay.
Well, I think the answer would be the availability of the appellate review of that action, the agency's view would stem from a review of that legal proceeding. A separate citizen suit being brought because an exhausting fact has happened. No, but doesn't give you the right.
Even I'm not quite. I don't think I follow that, and I may be missing something. But even in the circumstance in which the commission decides to take up the invitation of the district court and the contrary law determination, and then bring an action, which I think is what you're saying, is that the end of that could be reviewed.
I believe they under NRSC precedent, yes.
So even in that situation, it's not the same proceeding because they're bringing an action against that's a separate, it's just like the citizen suit. It's a separate action. It would seem a little bit odd in that separate action than to say that what we review is whether the contrary to law determination that gave rise to the possibility of that new action by the FEC was right. It seems like it's the same problem that we have here, which is that contrary to law decision happened. It created the possibility of this action. Now we have this new action. should we be revisiting the contrary to law determination that gave rise to it and that's now done? And it still seems, to me at least, it seems a little bit odd to say in this second proceeding, we ought to be taking a second look at something that's now done for the same reasons that I think you now are saying it's a little bit odd to do that in this context. So then there's no way, if that's true, and the new FEC action is the same as the new citizen action, then we are in this land, I think, in which AAN and parties like it would be in a situation in which they can't get direct review on appeal, they can't get review of it in a new action, so they never get review of it. Now, the answer to all this may be, actually, they should get an appeal. That I think is possible. I know.
I have an alternative
I
suggestion.
think our court said that, but that's what I'd leave to you. And I mean, you're obviously welcome to get assistance wherever you want. But from your perspective, at least, I take it the answer is that there's no appellate forum then. And maybe there is one, but just from your perspective until you hear more.
There is, again, the appellate form we appropriate I think in the FEC enforcement action case under the NRSC precedent, where they did go back and look at the.
Is that right? There's precedents where they go back and actually look at.
Yes, and I'm sorry, I apologize, I may be wrong, to follow the NHA or try to find out the actual case. But there was a deadlock, a court judgment reversed it. It went down, the FEC decided to enforce. In the enforcement action, it was on appeal, so I don't know what happened in the district court there. But on appeal, the appellate court said, we're going to go back and look at the actual original decision, think that was wrong, define contrary law. Because of that, we're not going to allow this enforcement action.
And you at least agree that even that is contingent because it depends on the FEC coming in and doing something, even if that's true and that's.
Well, true, because of course you need to be injured, right? So if the FEC, if here the FEC on remand dismissed, which again did here, and we had not legally challenged, AM would have no appellate. Right, because
what do you mean you still need to be injured because you're injured by a citizen suit?
Well, my hypothetical is, let's say we lost Crew 2, for example. There was not a contrary law judgment. There would be no appellate right for AAN there as a prevailing party, essentially.
Right, you would have.
So, we would have a right to appeal, exactly. Yeah. So there's a requirement, of course, that you be continually injured somehow to bring your appellate right. So there's not an automatic right to appellate right no matter what. You don't get to bring a challenge or prior decision. You have to still have standing to do that.
Okay.
Thank you. So the way I understand the way this statutory scheme works is the question is whether AAN needs to register as a political committee, and that's AAN's interest in this case. The FEC has the ability to decide whether they want to bring an enforcement action to make that determination. And the way this statutory scheme works is there's this procedure which has happened here where they can whatever they decide, it can be challenged as contrary to law, it can come back to the FEC. But ultimately, if the FEC doesn't proceed, as in this case it did, we have a citizen action. And in the citizen action, AAN is a party. AAN is being sued by Crew, and AAN can litigate whether it has to prove that it is a political committee or not. So its recourse, because its interest is whether it needs to register as a political committee. And that gets litigated in a court of law before the district court in the citizen suit and can come up on appeal. The exercise of FEC's prosecutorial discretion is not something that AAN should be able to invoke. That's not AAN's business. The FEC is not a party to this proceeding. The case in which it was litigated whether FEC properly exercised its enforcement function or not has been litigated, it's done. It's a separate case number. This is a new case. It's got a new complaint. FEC is not a part of it. So FEC's enforcement decision and its prosecutorial discretion should not be a part of our analysis here. And in this statutory scheme, the statute says if there's a declaration, the court may declare that the dismissal of the complaint or the failure to act is contrary to law, and may direct the commission to conform with each declaration within 30 days. That suggests to me the textual reading of this is that you don't look behind the contrary to law determination. As long as it was declared, whether it was right or not, you've exhausted and you're properly in the district court. And AAN gets to litigate whether it's a political committee or not here before the district court and then appeal that up to us.
I think that's absolutely correct, Your Honor.
That's not. I don't understand how. I don't want to have a back and forth between judges because I'll just put the question to you. Yes, that is an argument that you haven't made, but you think it's correct. It still doesn't address, as far as I can tell, AAN's position, because of course, yes, AAN can litigate the legal merits of whether the legal theory that you've propounded is right or wrong in this proceeding. They have absolute leeway to do that. Of course they do. What they have lost is the ability to stop this from happening in the first place. And yes, that was an exercise of prosecutorial discretion in the first time around. But it's also true that suppose you had a case in which, for example, the first time around, the contrary to law determination, a district court, and no district court would do this, but I'll just throw it out as a hypothetical. A district court just says, I know that exercises of prosecutorial discretion are supposed to be non-reviewable. And I think that this is an exercise of prosecutorial discretion, but I'm going to go ahead and review it. I'm going to say it's contrary to law. And then I think where you would be is you would say, no appeal of that.
Well,
no appeal of that, right?
First off, the FEC, of course, has a right to appeal. And so if the FEC's interest in protecting its right to protect prosecutorial discretion.
Right, but did you oppose AAN's intervention motion in the?
No.
Okay, so you think it was fine for AAN to be part of the contrary to law proceeding because their interests were at stake?
On the Crossroads precedent, yes.
So their interests were at stake. They weren't a total disinterested bystander in the initial proceeding. They clearly had a concrete interest at stake, even though what was going on there was an assessment of whether it was an exercise of prosecutorial discretion.
Well, I mean, their interest, of course, is that they don't want to be found a political committee, right? That's what they came in to defend. If a court were to, do what you did, say, I'm ignoring all the precedent, I'm just going to find this reviewable, I don't care. Obviously, there's an appellate right for the FEC, which could take. The FEC obviously can on remand conform and sort of essentially nullify, fix that problem, do it again. They could say again, we're going to exercise discretion, dismiss it yet again. We think it's fine. Thirdly, in that particular situation, make a mandate.
They never get a second. I think his point is very well taken that AAN has full opportunity here to argue that they're not a political committee, which is that they obviously have a concrete stake in that issue, and they need to get the ability to argue that. What they've lost is the ability to be vindicated in their view in the first proceeding and the contrary to law proceeding that was non-reviewable. And so there should never have been an occasion for the citizen suit to be filed. They've lost that, right?
Well, they would, in this hypothetical situation where they can't bring this lawsuit at all, then essentially they haven't lost it because they can always, again, appeal it in those proceedings. What they have.
No, I don't even think you've come up with one hypo in which they can appeal it. Your hypo has always been that the FEC can do something and then that can be appealed. There's no.
Yeah, exactly. So at some point, that chain of events, those decisions, it's like interlocutory district court decisions. At some point, those all go up on appeal, right? So at some point, that chain of district court administrative proceedings.
No, this one didn't.
No, I know this one did not, but hypothetically, it could if they remained an injured party and they could go up.
There's no, in this scenario, in exactly what happened here, there's no way to get an appellate referendum on the contrary to law determination.
In this proceeding, and this hypothetical, no, because this proceeding, we have met, this proceeding, the propriety of this lawsuit doesn't depend on whether there was a proper contrary to law judgment or it was reviewable or anything else. It depends on, did we exhaust our claims with the FEC? We did. Therefore, the propriety of this decision planning is done. That is clear.
AAN, in this proceeding, AAN, based on the way you're now looking at it, would never get appellate review of the contrary to law determination.
Not in this proceeding. And imagine the statute was different. Imagine the statute said, instead of a final judgment in contrary to law, it'll be handled if an appellate complainant goes to court and receives defeats a motion to dismiss, something interlocutory, right? If that happens, then you can bring your lawsuit. As long as this interlocutory order has been issued. That's it. You can bring your lawsuit. The fact that it happens means our lawsuit is now possible to bring.
Right. So the upshot of that is that AAN, even if there was everybody agrees the contrary to law determination was grossly wrong, and there was a decision by a district judge to say something's contrary to law, even though it was pure prosecutorial discretion, what the commissioner, the controlling commissioner say is, we're not looking at the legal merits at all. Actually, we don't care about the legal merits because this is in bucket C of substantive claims. That's a bucket that I never want to look at. It has nothing to do with the legal merits. And the district judge says contrary to law. and then somebody files a citizen suit, you'd say, too bad to the AANs of the world. They now have to deal with the legal merits of that.
Well, I think in my hypothetical, the interlocutory decision defeats the motion to dismiss. We could then bring a citizen suit under my hypothetical statute. That citizen suit is now perfectly valid and go forward. The proceedings of the district court continue, let's say it results in final judgment, AAN appeals that decision. Unless it turns out that interlocutory order was wrong, the court should have dismissed. I think under basic case law, as long as that decision was within jurisdiction, it existed. If that's all you need to bring the citizen suit under the statute, you got to bring it. It doesn't matter that that was legally erroneous, wrong. This decision issued, that is the fact that the statute conditions the citizen suit on.
Right. I think I totally get that. I still am not understanding why you're fighting what I think is just, I don't think it's disputable that the way you're looking at this proceeding, the one that's actually happened under the statute that we actually have, under the way you're now positioning yourself, AAN would have no entitlement to an appellate referendum on the contrary to law determination.
Not in these proceedings, in this.
Right.
It's a pure argument, yeah.
A question, and I just am not that familiar with this. The first proceeding with the contrary to law determination was about FEC exercising its enforcement power. And AAN was an intervener in that. Does an intervener have a right to appeal the enforcement of the FEC if they're just an intervener? Like, say the FEC has no interest in appealing its own ruling and its prosecutorial discretion. Can an intervener do that on the FEC's?
No, Your Honor, under an affairs case law that, especially because the order is a remand order. Essentially, it's not it actually doesn't end the case. It just sends it back down to the FEC for more proceedings. And courts have recognized that it's a remand order, it's not final. Proceedings are continuing.
No, I understand.
They're just back to the court. The FEC can appeal because the courts consider the agencies have essentially an injury that can't be remedied through later proceedings. The injury is we have to follow new proceedings, we have to apply new standards.
No, I understand that. My question is that the FEC has no interest in appealing. Can an intervener appeal on their behalf? The issue is about the FEC's prosecutorial discretion. And if the FEC is not interested in defending that, can an intervener do that on behalf of the FEC?
No.
But I don't think you made that argument in the appeal of the contrary to law determination. I thought your argument was it's not final. I think, as I understand, Judge, and I want to make sure I'm.
I think if I'm answering your question, is it that your question that would they have standing to argue error on the appeal, or is it they can't bring the appeal?
Can they bring claims on behalf of the FEC? Because we're talking about prosecutorial discretion and whether the FEC should exercise its prerogative to investigate an alleged election violation or not. And so FEC is not here telling us we exercised our prosecutorial discretion. That decision was wrong. We have an intervener here asking us to do that. And my only question is, can they do that?
When there's no case on that, because usually the few times I've tried to be appealed have been denied for not being final. So we don't have any case law understanding that. I think there'd be obviously a very strong argument that someone defending the prerogative of the FEC, not their own legal status, would be beyond their standing as an appellant to raise that kind of issue.
So then the fact that AAN doesn't have a recourse to appeal that decision, and that's a function of the fact that they're an intervener and it's not their right. It's not that they're being deprived of something they're entitled to. Are they?
Well, I think that, again, I don't think there's any clear case law on that, but I think that would be a very sensible reading of understanding.
That would be something new based on what I totally take the point, but you didn't make the argument in the contrary to law proceeding on appeal that AAN, you opposed the appeal. You opposed AAN's appeal and you opposed your.
The second, not the first. The first, actually, the FEC who opposed the appeal, in both.
Got it. Well, I thought you opposed both times and the FEC only did the first.
No, we actually tried to obey the first one and we took no position on whether we dismissed the first time.
On appealability the first time you took.
That's right, yeah.
I see. Okay, so the second time you opposed appealability, but you didn't oppose it on these grounds. You opposed it on the ground that the determination was non-final.
Well, essentially, there's no jurisdiction to take the appeal because there's no final judgment to even appeal over. So there was nothing to even,
But you didn't make the argument that even if it's final, AAN is the wrong party to bring it.
Well, it would
The
be,
FEC could bring an appeal.
essentially never got to that point because the argument would be, of course, I'm sure, imagine AAN didn't file the papers, would be the contrary law judgment was wrong, but also wrong in the merits. We're not a political committee. The tests were wrong, those kind of things, which I think does have standing to bring in. So we never got to sort of parsing what the various errors this session was because it just never was a final judgment to appeal.
Can I see if I understand the upshot? A citizen suit provision is only triggered when the FEC acts contrary to law. Am I right so far?
When there's a judgment that has that contrary to law, correct?
Okay. So citizen suit jurisdiction only triggered when there's that judgment and by a district court. And AAN cannot challenge that judgment on appeal.
Well, no. If the FEC had appealed, it could then, be brought up. But on its own, no.
Okay.
That is not a final judgment remanding.
And I guess that it does seem odd that jurisdiction could be triggered by an erroneous district court judgment that was not subject to appeal.
Well, I think it's just jurisdiction, it's the exhaustion requirement. It's sort of a trigger for the lawsuit. But the way the statute is written, all that's required is the district court to make issue that kind of decision. That triggers appeal, as if the statute had written that an interlocutory order that had not been appealed, as long as it said X, just like here, a statement, the new model is a statement saying possible discretion, we can't appeal that or do anything else, that sort of has its impact. So yeah, under the statute in this reading is there is a district court order, which there is. There is a failure to conform, which there is. That permits to bring a suit. There is no requirement in the statute that be appealed, that it be correct under the law, that, or anything else. It's just the fact that the court order issued, a declaration, the fact of exhaustion, that gives rise to a lawsuit. But I know I'm well over time.
Well, yeah, now we've talked a lot about whether AAN has standing to take an appeal and all that. Maybe we should hear from AAN about what they think about that, unless my colleagues have further questions this time. Okay, we'll give you some time for rebuttal too.
Thank you.
Ms. Murphy.
I think it's now officially good afternoon, Your Honors, and may it please the court, Erin Murphy on behalf of AAN. I was prepared to talk about the arguments that were actually raised in Crew's brief today, so I'm happy to start there, or happy to start with the discussion that's just been had, whatever's most helpful to the court. But we certainly do think that on the basis of the arguments that have been presented in this case, that it's quite clear that Judge Cooper was right, that this decision, that this case is controlled by new models. The exercise of discretion here falls squarely within what both new models and CHGO recognized as when you exercise prosecutorial discretion, even if that is grounded in legal reasoning, it remains unreviewable because the strength of the merits of a case is a classic factor for exercising prosecutorial discretion.
So before we go down that road, and I do have some questions about that, can we just talk about whether we ought to be doing that at all?
Sure.
And I guess the question is this. I'll start off this way, and then there's a few things I know that it'll be helpful to get your views on. Let's suppose that you were allowed to take an appeal. Let's suppose that the way that it happened the first time around is that our court said, it's actually final because it's final as to the thing that's in issue, which is the contrary to law determination. That's never going to be resuscitated no matter what happens before the agency, because either you're going to have a new action from a citizen suit or you're going to have a new action from the FEC. That's a different thing. There is finality as to this, so we'll take it up. If that were true, then what's wrong with the world in which that's done and over? In this proceeding, the only question is whether there was a contrary to law determination, just whether there was a declaration, the fact that happened. Now that's all done and over. This is not, you don't get collateral review of that here. You just go forward to look at the legal merits of the claim.
Sure, there might not be anything wrong with that world. Our problem is that's not this world. I mean, it's not just that we couldn't take an appeal. We took an appeal. We took an appeal twice, and this court dismissed it.
Then let's just bracket that for a second. So then, do you think that that's a wrong view of the statute? I mean, the statute we have before us is 8A, which tells us something about this proceeding. It seems to me that that's a pretty persuasive view of the way this statute is supposed to work. If you put aside appealability and fairness,
So, I mean, I guess what I would say is I think the right way this statute has to be interpreted is that at some point, we're essentially a citizen too, and we're the sued party has to have a chance to resist all the way up through a final judgment, the triggering determination that allows a citizen suit to go forward. And if Congress wanted to structure a regime where that happens earlier in the process, okay. If Congress wants to structure a regime where that happens later in the process, okay. But if Congress has structured the entire regime around the ability, you only get to bring a suit here. It's not just kind of exhaustion in the sense of taking a few steps before the FEC. You only get to bring a suit if the FEC acted contrary to law, and we should have a full and fair opportunity to litigate whether the FEC acted contrary to law.
Suppose that I'm looking at the statute and I think the best reading is that in this proceeding, which is a new action, new parties, new case number, all of that, we shouldn't be taking a second look at the correctness of the contrary to law determination. And I think that I'm not sure whether an appeal should have been allowed. Maybe it should have been allowed, but that's water under the bridge at this point. What gives me the entitlement to say, although I think the proper reading of the statute is that in this proceeding, we don't take a second look at what happened already in the first proceeding, because there wasn't an appeal granted, I'm going to do that anyway.
Well, first and foremost, party presentation principles. There is no question that this argument has not been raised by Crew before this court until I'm not even sure, it took a while to figure out if they were even embracing it today. I take it they now have. I don't see anything about this argument that is a jurisdictional argument, that is something that the court could reach out and address in fairness to us when there's been a fully briefed appeal.
Why
and they never made this argument.
Why isn't it a jurisdictional?
Because I don't think it turns, nobody's disputing. I mean, we're disputing that the district court had jurisdiction to go forward. They're not disputing that the district court had jurisdiction to go forward. And so I don't see how the district court's jurisdiction over this matter turns on the question of whether it was able to look behind the determination about whether the underlying action was contrary to law.
If you think it's a jurisdictional question, then and we think, let's just suppose we think, and just and indulge hypothetically, even though you may resist it. We think actually the district court totally had jurisdiction to go forward because it shouldn't have been taking a second look at what the prior district court, which actually in this case happens to be the same district court, did. And so then we'd be saying, actually there is jurisdiction to go forward.
I think what we would all agree is if there's something jurisdictional here, it's the question of whether there was a judgment that was contrary to law. I don't think the arguments that are made in favor of or against whether there was a judgment that are contrary to law, those don't strike me as jurisdictional arguments. The district court could be right or wrong in its assessment of whether there was a previous judgment that there was something contrary to law, just as it could be right or wrong in its assessment of whether the FEC actually failed to act in a manner or failed to conform to its judgment. But I don't see how the arguments about whether those are merits arguments about
them. Going to a jury. I mean, it happens all the time that parties make arguments about jurisdiction that are raised or not raised, and we still have to decide what's right or wrong about jurisdiction. So
I don't think that there's, I don't take Crew right now to be arguing that the district court lacked jurisdiction because it looked behind the determination. They're arguing it had jurisdiction,
right?
Because it looked and it had jurisdiction because they think the district court was wrong, but they also think even if the district court had analyzed it this way, the district court still would have had jurisdiction. So it's a bit odd to be saying, that this court could kind of reach out and decide an issue that Crew never pressed at all in its appeal on the theory that actually it's another basis on which the district court had jurisdiction. I mean, that just seems kind of at odds with the notion of usually you raise arguments that parties haven't raised if you're worried that the lower court didn't have jurisdiction, which is not the argument that they're trying to defend at this point.
That usually happens, but it does go to the jurisdictional question. Even the way that you frame the case, it goes to a jurisdictional. It goes to whether the district court had jurisdiction.
I mean, I think look, frankly, we haven't briefed any of this, so I cannot say I've done a lot of research on whether it's appropriate to think of this as a jurisdictional question. But certainly we think that a district court can't proceed with this kind of case unless there's been a contrary to law determination. We think that's a threshold requirement in order to have a citizen proceed in district court, that you need both the contrary, a previous judgment of contrary to law and the failure to conform with that. Now, whether that is jurisdictional in the truly jurisdictional sense that we're talking about here, that would excuse complete waiver of this argument, I don't want to fully take a position on that without having.
Whose burden is it to show jurisdiction?
I'm not actually sure. I mean, I would think it should be their burden in the first instance to show that the requirements to bring a citizen suit are met. Because to get into court, they have to show that there has been the previous judgment and the failure to act. So I would think that's their burden in the first instance to show that those two things are, since that's the prerequisite to being able to proceed with a suit, I would view that as the plaintiff's burden in proceeding.
Could we write an opinion along these lines? If Crew had made the arguments we've been discussing, they may well have demonstrated our jurisdiction. But instead, they made the three arguments that they make in their brief. And those arguments do not show that we have, or that the district court had jurisdiction. And so since they haven't shown that the district court had jurisdiction, we affirm the district court's dismissal.
So here's where I'd quibble just like a little bit. I mean, I would more put it as kind of, I want to be clear that we're not agreeing with their position on this. So we're certainly not, I'm not standing here to say if they'd made this argument, we would have had no responses and the court is right. So I think if the court were to say essentially, they had the burden to establish all of this, they didn't try to establish it this way, so that's waived and that's done. Here's the way they tried to establish that the district court committed error, and they're wrong about the ways that they tried to establish error, great. And this court could essentially leave for another day the question of, in a case where a party wants to raise it, and perhaps leave for another day the question of whether this court was wrong to dismiss our appeals. But particularly with all of that water under the bridge, and this being a case where we took appeals and the court denied our appeals, to now kind of say, well, maybe we were wrong about that, and maybe no one ever even made any arguments about it, but now at the back end, we're going to kind of say too bad for you, seems awfully problematic and unfair as a matter of party presentation, absent some truly jurisdictional requirement that the court has to look at that, and I just don't think there is one.
So I'm making sure that I'm spinning out the same, I think it's a different sequence, but it might be the same one. Do you think we could do the following? Because of party presentation, name your set of issues, we don't get into this threshold question of whether it's even appropriate for the second round proceeding to look at the merits of the contrary to law determination. And so we go forward to engage on the terms that you all have presented the case. And on those, we actually think that the district court had authority to go forward. That seems fine to do that.
I mean,
you disagree about the merit.
Yeah, as a procedural matter, if you were ultimately going to conclude one way or another that the district court should have gone forward, I don't think it matters if you unless again there was some kind of truly jurisdictional aspect to it. I don't think it would matter which one of those bases you proceeded on reverse. Obviously, I'd love to spend a lot of time telling you why I think that would be absolutely wrong under new models in CHGO. But as just a procedural matter, I guess it's this. I have kind of the same answer whether you're coming at it from we win or we lose. I don't think the court has to address that argument here. And to the extent the court really wants to address that argument, I would strongly urge that we have an opportunity to do some supplemental briefing on it, especially because it makes no sense to be able, as I take Crew to be saying, if we could challenge it in the FEC proceeding, I cannot fathom why we can challenge it there but not here. And that all just seems a little hard to explain.
We're definitely talking about stuff that wasn't briefed, but because we've talked at length about it and we're trying to get as holistic of a picture as we can. Can I follow up on what Judge Pan's line of questioning? So your AAN, in that first contrary to law determination, you were allowed to intervene.
Yes. And
nobody disputed had enough of a stake in the controversy to intervene. And then the question becomes, can you take an appeal? And let's suppose that we, just for assumption purposes, that we agree with your position back then that actually was final. So there wasn't a non-finality bar. But what about the question of whether AAN is situated in a way that should allow it to appeal when the question is whether the FEC's exercise of prosecutorial discretion should preclude the reviewability determination.
So here's why it's a little tough for me to answer that. I mean, my inclination is to say, yes, we should be able to appeal, but it's a little bit of a counter, it's a hypothetical that's builds in something that I think is a little problematic, because to me that the part of the reason that an intervener often can't appeal in this context is interwoven. It's intertwined with the finality issue, because the point is, look, the intervener shouldn't be able to get ahead of the agency who gets to decide in the first right whether it wants to conform, whether it wants to do the same thing again, what it wants to do. So it's a little hard to separate those things out and treat it as, well, it's a final agency, it's a final determination for purposes of the private party, but not for purposes of the agency. So I think there's the reason that led this court to say this isn't final is not sort of specific to interveners, but would end up probably applying anytime you have someone other than the agency, because the reason it's not final is because it's a remand to the agency.
Is it true that you said something as a premise that I'm not fully up to speed on? Is it true that there are cases in which an intervener has been denied the opportunity to appeal on the theory that the agency didn't appeal and therefore the intervener cannot?
I mean, I'm not sure. I'm actually just not sure. I think typically they get dismissed on basically just by saying it's a non-final judgment. But when I think that
But that would be a non-final judgment regardless of which.
it's a non-final decision. It's a non-final decision either way. This court does have precedent that allows greater latitude for agencies to appeal non-final decisions in the context of a remand because of the prospect of the agency being foreclosed from subsequent review. Now, you could extend the same principle to private parties and say, I think that's how you'd have to get there if you wanted to kind of redo this from the start and ensure that we had appellate rights. I think you'd take the same principle and say, look, just as we would allow the agency to take an appeal because it would be foreclosed from later doing it, if it is forced to go conform and change its action, we allow the private party to take an appeal because otherwise they may be foreclosed from later doing it. But again, water under the bridge, because this court denied those arguments. When we made those arguments, this court dismissed our appeal. But I think that's, if in the future you wanted to take a different approach in which the kind of appellate rights occurred earlier on rather than at the end, I think that would be the best theory under how to get there.
What is the status of the prior case involving the FEC's enforcement action? I know that it got remanded, they didn't take action, and now the citizen suit started. Is that other case closed? I just want to confirm that, because I guess theoretically, if it weren't closed, you could file a motion to reconsider that case under new models.
So I'm sorry, there's so many cases here. I want to be sure I'm responding to the one you mean.
So the case in which there was a finding that it was contrary to law and it got remanded.
Okay, the 2000,
the most recent one, and then no action was taken because one of the FEC commissioners chose to not let there be a quorum.
Right.
Is that case closed? If it's not,
we took an appeal from that district court contrary to law determination, and it was dismissed. If I'm following you right, when the district court held
at an earlier point, though, right?
So the district court held in. So here's kind of the sequence, just to be sure we're on the same page.
Okay.
So we've got the 2014 statement of reasons.
Yes.
Which in 2016, the Judge Cooper says was contrary to law.
Yes.
We try to appeal that and our appeal's dismissed. Then we have the 2016 statement of reasons. And in 2018, Judge Cooper holds that that's contrary to law. We tried to appeal again and that was dismissed. And in the interim, this lawsuit was filed.
No, but then there was a remand. Your appeal was just.
There was a remand, but there was no agency action.
And there was no agency action. So my question is that whole proceeding now closed?
It is as of, I guess it depends there's a whole separate line of appeals going on right now about what counts as kind of the closure. In 2022, the FEC closed the file on this case. Conclusively, they closed the file. At that time, Crew sued us again. So they've sued us another time in another district court action that's pending.
It's a different case.
Based on the now belatedly revealed 2018 voting patterns in the 2022 closure. But no action, the FEC never took any action against us. So we couldn't appeal anything the FEC did, which is what I understand to be Crew's position is the only way in which they think we could have appealed is in a context where the FEC enforced against us, and then we could defend against the enforcement action. But absent somebody, either the FEC or a private party suing us.
The FEC could have appealed
They,
Judge Cooper's,
they arguably could have appealed, this court,
and it's their.
they didn't appeal. So this court never confronted the question of whether it would have fallen into the doctrine this court has that allows agencies to appeal even when, it's a non-final decision. So it's a non-final decision, it's just as non-final as to them as to us. But there is doctrine in this court that generally gives agencies greater latitude to appeal in that context. But I don't think
There was an appellate, right? It's just FECs and not AANs.
there was an ability for the FEC to try to take an appeal. They did not. But I don't think that can, to go back to the question that you put earlier to Chris Counsel, I don't think our only interest here is in not being determined to be a political committee. We have an interest in not being subjected to what we believe to be an unauthorized citizen suit. And so, it's not only the FEC that has an interest here.
Any precedent that supports, you being able to proceed on this sort of but-for causation theory?
Well, the statute itself doesn't allow a citizen suit to be brought unless the prerequisites for the
Correct.
statute
You're
are
saying
satisfied.
but for this finding, we wouldn't be here. But is there any authority that supports that
This is
supplies jurisdiction to?
this is the only one of these suits that's ever gotten past a motion to dismiss. So there's essentially not a heck of a lot of authority about how these AA suits work at all.
Can I ask this question along these lines? In 2014, when the first contrary to law determination is made, you took an appeal, right?
Yes.
And the FEC, what was the FEC's stance on that?
I'd have to say I did not review the papers on exactly what they.
You didn't know this was coming.
Yes.
Okay, because it would be interesting to me to know whether the FEC made the argument, because the FEC didn't take an appeal, right? We at least know that.
They did not take an appeal.
It'd be
They did not
interesting to me
take an
whether the FEC made the argument that why are we even entertaining this appeal, because AAN just doesn't have any entitlement to step into our shoes.
Yeah, no,
I don't know whether
and
they made that argument.
I'd venture to guess they probably just made the argument of we have the ability to decide what to do on remand. And as they did, they proceeded to take the same action again and incorporate all of their previous reasoning. So, I think that they just viewed it through that finality lens. But I confess I did not.
Sure.
I did not review all of the papers of the previous appeals in this case.
So I have a question on the merits. So my question on the merits is this, just to start us off. So suppose you have a controlling commissioner's recitation of the reasons for not going forward that says, we just think the general counsel's legal theory is wrong. And here's 20 pages on why we think the legal theory is wrong. Everybody agrees that that's reviewable. Everybody agrees that can be a contrary to law determination. And then
If it's purely, purely legal, yes.
Okay, so they do that. Then let's say, in addition to the 20 pages, they add a sentence that says, and therefore, in an exercise of prosecutorial discretion, we elect not to go forward. Does everything change?
I think the best reading of new models is yes.
Okay, so then my question about, there's different pieces of new models that point in different directions. Of course, there's footnote 4, which points strongly in one direction.
Yes.
There's other parts where they talk about it. There's something that's distinct that may be seen to point in a different direction. But let's just step away from what the cases say and just think about this just conceptually. I guess what I'm not quite following is, if everything changes based on adding the sentence that says, and therefore in an exercise of prosecutorial discretion, we decide not to go forward. Wasn't it obvious that when the legal memo was rejected and the commission decides not to go forward, that is an exercise of prosecutorial discretion. By definition, it's an exercise of prosecutorial discretion because they've decided not to go forward. And by definition, it's because of the reasons they spell out. So, but we know that that's reviewable.
Sure. And, that in a sense, like that's relitigating some of what, all the way going back to the DCCC case, where the FEC's position was, look, if we dismiss because of a deadlock, like that's obviously an exercise of discretion and that's the end of it. Now, this court has said, no, we're not going to accept that. We want you to explain your reasons. But I don't think that means that you're kind of paralyzed from offering reasons that are not legal. And here, if you have a commission, if you have commissioners saying, here's why we think the case doesn't succeed, and we don't think we have authority or whatever it may be, but we also would exercise our discretion because of that. That is just a classic.
So I agree. So that's the thing. I think I agree with you. I think that's a very strong position that considering the legal merits is a classic exercise of prosecutorial discretion. I think to me, that's hard to argue with. The question to me is which direction does that point? Because if you have a memo, if you have a controlling commissioner's memo that only relies on law, we're in a world because of this statute where that's reviewable. Everybody agrees that's reviewable. I think that's quintessential prosecutorial discretion for exactly the reasons you spell out. And if we know that that's reviewable, it's hard for me to see why the world changes when they just tack on a sentence that says the very obvious thing that what we're doing is engaging in a classic exercise of prosecutorial discretion and not going forward because we think this case is legally non-meritorious.
I mean, I guess I resist a little bit the premise. I mean, the FEC itself seems to view there to be some degree of distinction because they don't invoke prosecutorial discretion in every case. So they, you know, and some of this is a bit artificial because of the way this court requires there to be the views of the controlling commissioners and all of that. And so, you know, sometimes when we're talking about this, we're not even necessarily talking about the actions of the commission itself, but
we're past
that's all just kind of water under the bridge.
Then explain to me in the real world, what's just is just a real world matter. What's the difference between a controlling commissioner's statement that says, we disagree with the general counsel as a matter of law, 20 pages, therefore we're not going forward. If that's all they say, everybody agrees that's reviewable. If they tack on, therefore, in our exercise of prosecutorial discretion, which of course we're exercising because we're prosecutors, we elect not to go forward. I think that's non-reviewable.
Look, the exercise of prosecutorial discretion necessarily takes into account factors simply beyond, we think this fails. You know, I mean,
No. I'm assuming, sorry, I didn't mean to cut you off, but I'm assuming a hypo. Let's just assume a hypo in which the agency just says, we're not thinking about anything else. The only reason we're not going forward is because of what we just said, which is that legally, we just think this is dubious. Now that, I think I agree with you, that is classic prosecutorial discretion.
And to me, you know, I mean, if you can't see the distinction between the two, that's a reason to kind of revisit where the court started, not a reason to revisit where it ended. Sure, but you also can't revisit new models right now. And maybe all of this is a reason to think about, you know, where is the starting point and what is and isn't discretion here. But I actually really, I would say, I want to be clear and make some arguments about this case. Like, I don't think that matters that much here because I don't think that's this case. Because if you look back at the 2014 Statement of Reasons, it's not simply we think this case fails and therefore we exercise prosecutorial discretion. I mean, there's the principal point is.
We can argue about this because I'm just trying to understand the logical upshot of the position. And it strikes me as quite something to say that what is a classic exercise of prosecutorial discretion only becomes unreviewable prosecutorial discretion when somebody says, I'm engaging in a classic exercise of prosecutorial discretion.
And again,
it seems to me
I mean, I hear you. And I suppose it's just my response to that is that means there's something we haven't put in the bucket that we should, not that we should take a bunch of things out of the bucket that are in there.
And on whether we should put that into the bucket, it's just for us as a panel.
Is not a question any more than it is open to this court to take things out of the bucket that are already there. So, you know, I think there are very fair arguments to be made about exactly how all of this works out. And, you know, maybe some of that works a little better if you actually just examine the vote to close.
If you put that into the bucket, then what's reviewable? What's left?
What's reviewable is the case where, and it happens, the commission doesn't invoke prosecutorial discretion. They really just say.
But I think I just asked that question because maybe I missed something. Aren't they?
Oh,
they're necessarily engaging in prosecution.
So here's, if you want to put into the bucket even when they don't invoke it by its terms, if that's what you're asking me, I think the thing that's still left out is when they say, we believe we lack jurisdiction. Because if you say you don't think you have jurisdiction, you're saying I have no discretion to exercise. I've included
this statute that clearly provides for review. The only place in which that would apply is where they say they don't have jurisdiction.
No, because I'm assuming your hypothetical of putting something into the bucket that this court hasn't put in the bucket.
Yes, because I'm assuming that it sounds like it's hard to draw a distinction between that.
I actually think that there's really there's a difference in my mind between kind of a case in which the commission actually has, say, like a majority who dismisses. You know, it's not. I mean, all of this is a little bit artificial because you're reviewing the vote and then you're reviewing the dissenting commissioners and then you've got the later vote on closing the file. But like, let's just make it a little more simplified. And there's just one thing that we all agree is the motion to dismiss, and say 4 commissioners vote to dismiss, just to make it easy, leave aside the debate about whether 3 is enough, like 4 vote to dismiss. and they vote to dismiss and they offer a statement and they say, we're dismissing because we have found that there is no violation here. We looked at this, we have found that there's no violation here. I think that would be reviewable. I think that would be reviewable, and that's not the commission saying we've exercised our discretion to not go forward. It's saying, we got together, we looked at this, we made a determination, and our determination is there's no violation. Some of what makes this case feel different. I get it. It feels weird when it's a minority and all that. But again, that's just a product of this court's cases. But also, I think that's different from saying we're not going to proceed because we don't think that we're likely to prevail, or here what the commissioners really said. I mean, they said we don't think that this is a violation, but in their footnote about prosecutorial discretion, what they said is, at a minimum, the fact that the Seventh Circuit has already rejected our views is a reason not to go forward.
But even in your hypothetical, and I don't want to cut off anybody else's question. Sorry.
It's helpful to me.
Even in your hypothetical where you say would be reviewable, which is where they say, I find, we four commissioners, let's strip out the middle.
Yeah.
We four commissioners find that there's no violation here. You think that's reviewable?
I think that seems to be reviewable to me. I mean, you've got,
then on that one, it doesn't seem to me to be crazy for them to tack on a sentence. At least it doesn't seem to me to be a disconnect to tack on a sentence that says, and therefore, in our classic exercise of prosecutorial discretion, we don't go forward. And then that would be non-reviewable.
That's I think that's the best reading of new models, that they do that. At a minimum, if they say, if you wanted to draw a distinction between the therefore, because the therefore, I think you're building in the therefore because the therefore builds in, we've exercised our discretion because we think there's no violation, which to me, you could, if you wanted to parse things out, draw a distinction between a therefore and a, but even if, where they're saying, we think there's no violation here, but at a minimum, we think the fact that this is a close call is a reason to exercise our discretion. It's a fine line, but it's a line. I mean, there's a reason that we put strength of the case into the bucket. It's because the strength of the case is relevant to thinking about, do you want to expend resources on a case that is going to take a lot more time and effort, that may go all the way up to the Supreme Court, that may risk bad facts making bad law for the agency in other cases. It's not simply, it's not strong, so therefore we won't go forward. It matters for purposes of thinking about all those other enforcement priorities. So, if you wanted to say, look, we want to carve some room out for if an agency literally just says, we're exercising discretion because there's no violation here, and say, no, you've got to tell us something more than that. Going forward, maybe you tell the agency, you've got to tell us something more than that. I don't think you need to say that here, because they did tell us something more than that, because they said, at a minimum, we wouldn't go forward because the view of the general counsel has been squarely rejected by one of the courts of appeals already.
I mean, one way to think about this is there's going to be difficult line drawing questions no matter where we put the line. And it's hard to put aside, but let's just put aside what the cases say, because I think you can at least read the cases to point in different directions based on different parts of the opinions. Or let's just indulge me on that.
Love to converse about footnote 4, but sure. I'll indulge you.
Sure, indulge me just for the moment. Then the question becomes, okay, where would we draw the line? Given that we know that some things are reviewable and we know that some things are not, if they're laden with prosecutorial discretion in some dimension. One way to draw the line is to say, we look to see whether there's something distinct that goes to legal merits, but that doesn't treat with prosecutorial discretion at all, even though we think in some ways legal merits is always bound up in prosecutorial discretion, which is the line that you're suggesting we draw. Another way to draw a line is to say, well, the line we draw is to say that anything that has to do with legal merits is off on one side. Stuff that doesn't have to do with legal merits at all, like resources independent from legal merits, like the witnesses are all gone, that is the stuff that's not reviewable. That's another, and that seems, they're both difficult lines to draw, and definitely the second one, I think I'd buy the premise that the second one means that you're drawing categories of prosecutorial discretion, some that are in and some that are out. But it may be a more concrete line than the first one.
I just think it's really hard to square that with, even if, obviously I think it's impossible to square it with new models and CHGO, but I think they reached that conclusion because it's really hard to square that with a long line of cases explaining what prosecutorial discretion is. And the whole idea is it's not a matter of whether you're right or wrong about the bottom line. We can't kind of even review, if your assessment is this a close call, or your assessment is these aren't great facts and that's why we think it's a weak case. You're starting to look behind a lot more than a pure question of law. And you just are risking the courts getting involved and making the government redo its work all the time until they've kind of said the right magic words, when really all of this is an exercise of prosecutorial discretion. So it seems to me when you have this, what I think everyone would admit is a really unusual statute. Mm-hmm. And it's a statute that doesn't just say, you can review it for anything you want. It says you can review for contrary to law. And that means something. And I think you have to take that and give that meaning in a way that wouldn't just open the door to reviewing exercises of prosecutorial discretion. And I also would say, I think a lot of this, it's particularly arises in the context of the deadlocks in a way that I'm not sure it does quite so much when you don't have the deadlocks. When you have a vote on the merits by the commission about whether to go forward or not, and there's a majority and they can clearly articulate something. Yeah, they could invoke discretion, of course, when they're dismissing. But I do think some of this, discomfort and all of that kind of comes from those dynamics. But those dynamics, of course, are dynamics that Congress built right into the statute by requiring a bipartisan commission on which you need 4 votes to be able, not to be able to do anything, but to be able to proceed with any type of action against a citizen.
What do we know and what do we not know about the reasons why the agency exercised prosecutorial discretion?
So, I think the principle, the best explanation for why the controlling commissioners offered me is found in footnote 137 of their 2014 statement of reasons. And that's the footnote where after, the body of the opinion, their statement is, we would concede, devoted to explaining why they think the case fails on the merits, but that's where they drop a footnote and say, at a minimum, the fact that the Seventh Circuit has rejected the general counsel's position itself raises grave constitutional doubt, and those constitutional doubts militate in favor of an exercise of our prosecutorial discretion. I read that to mean, we got kind of 2 things. One, we like to be careful about taking cases up where a court's already said we're wrong, even if a court may say we're right. The whole debate here is about how to read Supreme Court precedent, and you can understand an agency thinking maybe we don't want to tee up the case. Could understand any set of commissioners here debating whether they want to tee up a case for Supreme Court review. And I take the second part of it to also reflect classic enforcement priorities. When we think something is close to the constitutional line, we're going to err on the side of protecting citizens' First Amendment rights. And that's a perfectly permissible prosecutorial discretion, exercise of discretion, especially when you've got an agency that operates in such a constitutionally sensitive area. If you go back to Heckler versus Cheney, that's pretty much the explanation the FDA offered for not exercising its discretion there. It said, we think we have no jurisdiction, but even if we did have jurisdiction, the courts are divided on this, and we try to err on the side of not going close to the line in light of it. That's perfectly permissible, and that's how I read footnote 137 of the 2014 Statement of Reasons.
Do you think we can know whether there were reasons for exercising prosecutorial discretion in addition to reasons that have something to do with the merits?
I don't think there's anything here that can tell us that. That's the explanation that we have. I would like, just say a quick word and to be clear, we absolutely think Judge Cooper was right that you can look at the 2014 statement, you can look at the 2016, which incorporates the 2014 by explicitly incorporates all of the analysis and reasoning, which he himself didn't view his own opinion of having eliminated prosecutorial discretion. So, we think either the 2014 or the 2016 Statement of Reasons gets you there.
Can I get back to one question about what we're doing here, back to the first set of issues, and I want to follow up again on the point that Judge Pan made. So let's suppose, and put aside whether you get to brief it, I totally take all your points on that. Let's suppose there is a precedent on point that says that in the context of a contrary to law determination, an intervener in the shoes of AAN can't independently take an appeal. It's the FEC's appeal to take or not. If that precedent exists, then do you see a problem with having a world in which in the second round, which is the citizen suit round, the intervener in the first suit doesn't have the ability to second guess the contrary to law determination? That seems like a coherent system to me at that point.
I do. I think there would be a real problem when the ultimate end of this is us getting sued. It seems to me there would be a problem that you should not lightly read the statute as never giving us a full and fair opportunity to challenge whether the prerequisites to sue us have been satisfied.
Even if the predicate for the denying you the appeal the first time would be that the prosecutorial discretion interests are one in which you don't have a stake, although everybody reads the statute the first time and knows that that's a prerequisite to a potential citizen suit against you, we would have already by hypothesis decided that that's just not something that gives you a sufficient stake in it so that you can take an appeal if the FEC doesn't.
I think that's right, because as I understand it, what you're protecting by not allowing the interlocutory appeal is the agency's ability to take the next action, not kind of their defense of the previous action. It's their ability to decide how they're going to conform to whatever the district court just said. And so you're leaving them the flexibility to, you know, I mean, they could take the vote and bring the suit against us themselves, in which case there'd never be a citizen suit, but at least I confess I haven't read the cases, but from what I understand Crew to be saying, we could challenge it even in the context there. You know, but I don't understand that line of doctrine to be about nobody should ever be able to look at whether the first determination was right. It's let's not tie the hands of the agency, which could respond to this in a variety of different ways.
Okay, thank you, counsel.
Thank you.
We'll give you 2 minutes for rebuttal. Mr. McPhail.
Thank you, Your Honor. I'll try to be very quick. First, respond to one question about the status of the AN case on remand. That's actually in district court right now. We defeated a motion to dismiss. AN filed and FEC filed. That case is being stayed pending resolution of this case because Judge Cooper said he wanted guidance on the impact of the statements invoking prosecutorial discretion in 2014 and 2016, the incorporation on how that. So that case is currently stayed, waiting guidance from this court in its decision. Secondly, I think there's maybe some confusion.
Can you explain how that got back before Judge Cooper? Because I guess there was a remand.
Yes.
And then the FEC didn't do anything. And how did it get back before Judge Cooper?
There was a vote to close in 2022, I think. We sued, that vote to close contrary to law. I think we may have filed that as a related case. I don't recall. It may have just also been totally a random wheel. I'm sorry.
So AAN is in that case too.
AAN is interviewed in that case as well.
So they could have filed a motion to reconsider.
They did.
Models in that case.
They did. Well, they filed to move to dismiss that case based on what their new models, all those rulings having effect in that case. And Judge Cooper denied that. He did not resolve the new models implications. He says, wait for this court to resolve that question. So that issue is live. It's just being held there, waiting this court's guidance.
But it means that their appellate rights are not dead necessarily, because FEC could continue to appeal up.
Exactly.
That case.
That issue could arise from those proceedings.
But they couldn't. They couldn't appeal.
Well, if we win Crew 3, I suppose now, yes, that would be the remedy would be remand, and therefore the same rules would apply about not appealing. There was also, I think, some confusion about, I don't think there's any dispute that this court has jurisdiction to hear this appeal, that district court below had jurisdiction to hear our citizen suit. I know AN's attacked our standing. There's been questions about that. I assume that's not an issue here. So it's not our burden here to show any jurisdiction of this court or the district court. Those issues aren't, I think, being questioned. The question instead is, does AN have the right to raise an error in the district court and here? And that really, I think, goes to Judge Pan's suggestion. Appreciate it. Sitting back on the bench helped me think about it. Is that it's a question of AN's standing to raise arguments. Does AN have an interest in this issue that it may assert the FEC's interest in prosecutorial discretion to defend itself here? And that is essentially AN's standing.
Do you know, by the way, when the case went up on appeal out of the 2014 determination, and FEC was involved at that point, right? They filed something?
Yeah, when on appeal, yes, they moved to dismiss the appeal. They're the ones who moved to dismiss the appeal.
And did they move to dismiss the appeal on the basis that AAN doesn't have any independent standing to bring an appeal since the commission decided not to?
I don't believe so, but I apologize. I may need to look at the papers again. I believe their focus was on
interest to make that argument.
Yeah. I don't recall. I remember the main focus on what the court held was that it was not a final order.
Right.
I also want to draw the court's attention to, looking back in our briefs, we did raise an issue in page 30 in footnote 5. We said, any error in reviewing the 2014 statement did not impact the court's jurisdiction to remand for reconsideration, citing the CLC precedent that said the rebuild is not discretionary. It's not jurisdictional. For the same reason, any error in reviewing the 2016 statement did not impact the court's jurisdiction to order the FEC to conform to that judgment, the failure of which is the trigger of this lawsuit. So we point out in the brief, in the opening brief, it's the
At page 30, note 5,
page 30, note 5.
Argument.
It is in there. I know we raised it below, and it was in a footnote in our brief, but it is in our brief. I also want to point out, I think AN's hypothetical is actually what happens here. In the first statement of reasons, they lay out in the very beginning, talking about why they think they're voting the way they did. They say the major purpose was not the nomination of election of candidates. His public statements, documents, spending show that accordingly, we could not find AN violated the act by failing to register reports of political activity. They reach a final legal conclusion. Their view is that there is a judgment here. There is absolutely no violation of law. That is their absolute conclusion. Oh, also in prosecutorial discretion. So an AN's hypothetical that somehow that would be reviewable, that is a 2014 statement.
Yeah.
I'm sure you're very familiar with the dissental and new models too, that I was asking you about earlier, Judge Millet's opinion. Aside from the part where it calls these two cases nearly identical, do you take issue with anything else in that opinion?
The dissent or the majority?
The dissental, Judge Millet's opinion.
Don't believe so. I don't know if there's a particular issue you wanted to ask.
No, just.
No, I think she's correct in that. And we point out a brief, the conflict between new models and black letter law. We point out additional conflicts in administrative law. As Your Honor was pointing out, the question of prosecutorial decisions are not reviewable, period, as an action. Whereas new model seems to make whether it votes to close the file or reviewable action. I also want to point out AN's asserted its injury here is being sued. The court's been very clear. Being sued is not an injury. That does not get you to court. You can't sue, you can't appeal just to avoid a lawsuit. And I also wanted to talk a bit about the merits here. The FEC isn't a prosecutor in this case. The FEC is a judge. The FEC has been clear about that. We are bringing a claim to the FEC. And it's not merely deciding whether it wants to go forward, as the impact in this case very much shows. It's deciding whether crew should be allowed to proceed. It's a judge, and judges don't have prosecutorial discretion. The FEC has admitted that fact. And in the case in Burlington, I can say there is no prosecutorial discretion when an agency is resolving whether private parties claim.
How do you square that argument with new models?
Well, I think you have to square the arguments. What new model says is that if there are conflicting precedents, you can harmonize them. And if that harmony means new models need to be cut back or not limited to its facts or not applied or expanded to these facts, that's how you have to harmonize those cases.
Why are they sitting as a judge if they're deciding whether or not to enforce?
Because they are looking at our complaint against AAN, that we present to them a complaint that we think AAN violated the law. And their decision has impact on whether we could sue. If, let's say, take out the prosecutor's discretion question. Let's say they said, in a majority opinion, the law is X.
But they were deciding whether you could sue. I thought they were, maybe I don't understand how this works. I thought that you would bring an alleged violation to them and then they would vote as to whether or not they should investigate.
They are investigating to see whether our complaint raises a reason to believe. Now, under the statute, if they find that, that would trigger an FEC investigation of the various statutes. But the impact of this is that if there's like a 4-2 vote that on the merits, we lose. That would also prevent us from bringing a lawsuit. We could go to court, try to get contract law, we would lose. We would never be able to sue ourselves.
But their investigation as to whether yours has merit is not prosecutorial in nature.
No, they are judging our claims. They are saying whether our claims have merit, whether it's reasonable, like our complaint raises
So if they
reason
think
to
it does
believe.
have merit, what happens?
If they vote to find reason to believe, then, well, a few things could happen. One, if there's a majority vote to find reason to believe and not a majority to exercise discretion to close the case opens at the FEC and the FEC investigate. If there's,
So why isn't that prosecutorial?
well, the FEC could say find reason to believe, majority still vote to close the file.
I know, but I'm just saying, why is it not prosecutorial in nature if they're saying this should go forward and now we're going to investigate?
Because it has an impact on whether we can sue. Because if they close the file.
It seems incidental, like for what they're doing.
Well, under statute in Burlington, that the agency makes a decision, even if it's closing its own, running its own litigation, own claims, if it's also cutting off claims of private parties, it's a judge.
All I'm focusing on is you bring them a complaint and say, we think there's a violation. They undergo a process to determine if they think there's any, I guess, there.
Yeah.
And then if they think there is, then they investigate the violation. And that sounds prosecutorial to me. That's all I'm saying. That doesn't sound like being a judge. That sounds like being a prosecutor.
So in the fact of like, if we were suing over only the impact, if let's say crew had no citizen suit, and we were only suing over whether the FEC should prosecute, I think then you run into questions of prosecutorial discretion, you run into issues, Texas Biden case. But the fact that what we are doing is establishing that we have legal claim and that we have exhausted any attempt to get a remedy out of the FEC. And so here, not only are we establishing, and here we show claims were exhausted. We couldn't get relief from the FEC. But had the FEC actually ruled and said, no, your claim has no merit, you actually lose because your claim is bad, that would also preclude us from bringing a lawsuit in court. Because it would sort of register our decision. We can't bring it. It's already been adjudicated as having no merit. Because of course we would go to a contrary law judgment, we would lose because the court would find it correct, and therefore we can't bring a lawsuit. And so the process here, what's going on, and it is slightly convoluted. I think it's done this way to make sure that the FEC can act as a gatekeeper on spurious lawsuits, but is trying us to test our claim before this agency, before we can bring our own lawsuit. So they're acting as judges on the propriety of our claims, or anyone else bringing complaints to them. That's their primary role there.
Okay,
And-
unless my colleagues have further questions.
Okay, well, thank you, Your Honor. I appreciate it.
Thank you, counsel. Thank you to both counsel. We'll take this.